Made pleasure lordship.
Yes.
The concern of my friend lordship, I beg to mention item number 10 and 20 lordship. I have some difficulties today lordship. 24 lordship. 10 and 24 lordship.
10 is what?
10 is for others for it, and 24 is the lordship hearing matter.
10 is IA is for what?
I is for the lordship condonation of delay lordship.
Why you have difficulty?
Lordship, today I have some difficulties lordship. I
Will
have,
issue notice?
already my brother is already appeared.
Already the notice issue.
Yes, already appeared.
45 days or 66 days?
No, lordship. It's a lordship 90 days period, but we have filed it after the 90 days. In our High Court judgment is that lordship we cannot file after the 90 days lordship. And other High Court says
So
that
what, how much it is delay?
it's a 45 days or 21 days some
That's what
delay
I'm saying.
lordship.
Yes, ma'am.
Are you seriously objecting?
He is objecting. So
Yes,
lordship,
yes, my lord.
he
You
is
have not filed an objection.
My lord, the objection has not been filed. The question of law is already covered by Honorable Guwahati. Catena of judgments passed by the Honorable Guwahati High Court itself. And Lordship 2-3 adjournment has already been granted. Lordship may fix a short date in this matter. If Lordship may please.
Otherwise, lordship, that particular issue is pending before the Honorable Supreme Court. So lordship may fix it after 1 week lordship, and he will not available up to 4 lordship. After 4 lordship may fix it. You are not available.
Mr. K. Gogoi, learned counsel for the applicant.
Lordship.
Item 10, huh? Learned CGC.
Lordship.
Learned CGC submits that he has some personal difficulty today, for which he praised that matter may be listed after 3 weeks.
Lordship, any
Mr.
date may be fixed.
Mr.
Any date may be fixed.
Mr.
Your
Your
name,
name,
your
please.
D. Rathi.
D. Raji.
Rathi. Rathi.
D. Rathi. Then a counsel for the opposite party has no objection. Mr. The prayer of the learned CJC is accepted. Mr. Accordingly, list this matter after 3 weeks.
Lordship, any date may be fixed, my lord. My lord, any
After
date.
3 weeks, you just
Lordship, in respect to item number 24, also similar prayer lordship.
24 is what?
24 is hearing lordship.
Again, it was fixed for admission hearing, my lord. Again, the matter is covered.
Again,
It is a covered matter.
2023 matter.
Yes, my lord. It is fixed for admission hearing, and it is a covered.
It's come on hearing column lordship. Otherwise, also
On the,
this
on
issue is
the joint prayer of learned counsel for the parties, list this matter after 4 weeks. 4 weeks.
14 November only, my lord.
4 weeks.
Much.
4 weeks.
Oblige lordship.
My lord, there is another supplementary item 26.
Yes.
I beg to mention, my lord, we have obtained consent from the other party. Adjournment may be granted, my lord.
This is 2018 matter.
Yes, my lord.
You are for? You are
Respondent 1 to 4.
on the prayer of Mr. D. Rathi. Your name is not there.
Lordship, I am appearing on behalf of Mr. SCKL.
Learned counsel appearing on behalf of Mr. SCK, learned counsel for the respondent number 124. List this matter after 6 weeks.
Much obliged.
6 weeks.
My lord, 2 weeks.
4 weeks.
Much obliged.
No, 3 weeks. Make it 3 weeks.
Much obliged.
I beg to mention item number 20, my lord. I have taken consent from other side.
20.
20, my lord.
Yes.
Mr. Peter also, my lord, he is some personal difficulty, my lord.
Mr.
A.K. Azhar. My name is not there, my lord.
You are appearing for
On behalf of Mr. Peter also there.
Mr. A.K.
A.K. Azhar.
Learned counsel appearing on behalf of Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Submits that Mr. P.K. Roy Chaudhary, learned counsel for the petitioner, has some. P.K. Roy Chaudhary, learned counsel, has some personal difficulty today, for which he prays that matter may be adjourned after 3 weeks. Prayer is allowed.
Oblige.
May it please the Lordship.
List after 3 weeks.
May it please the Lordship. Item number 27.
27.
27, Your Lordship. It's a hearing matter. The matter has been part heard by my lord in court number 27. Order dated 24/9 reflects that. I have my senior friend here appearing for the respondents and the other side also, the Pollution Control Board.
Why this has been listed here?
That is what has perplexed us, Your Lordship. In
Court
fact,
number?
court number 27.
It's not available now.
It is available.
sir.
My lord is sitting the division bench also, Your Lordship. But
Wrongly listed here.
I'll not say wrongly listed, but in fact, the word was not very conclusive in the fact that it was part heard. There is an order which states that hearing is inconclusive. Order dated 24/9. And the matter has been heard at length.
Let us see.
Yes. Yes. The matter here, Your Lordship, pertains to inter se seniority in the Pollution Control Board. 24/9, Your Lordship. 4/9. The second last order, Your Lordship.
Hearing remains inconclusive.
Yes. In fact, my lord has heard that matter on 3 occasions. Detailed hearing had taken place. A few confirmations await from our side before the court, Your Lordship.
Doesn't mean that it's a part heard.
It is part of Your Lordship. The reason we are saying this is because certain last minute instructions were sought from our end just to conclude the entire set of arguments. And that is the reason we're making this prayer, Your Lordship. Otherwise, the matter has to be reheard entirely.
Mr. N.K. Chaudhary, learned counsel for the petitioner.
I'm M. Sharma, Your Lordship.
M. Sharma.
M. Sharma.
Learned counsel for the petitioner. As well as Mr.
S. Borwa, pending
H.
counsel.
S.
Pending
S. or H.
S.
S for what? Sanatan.
Yes.
Huh?
Yes.
Sanatan.
Sanatan. Yes.
Sanatan.
Yes.
What does it
No,
S mean?
as for Sanatan, that's what I mean is Siddharth.
Siddharth.
Yes.
Sir, S. Siddharth Borwa.
Yes.
Learned counsel for the respondents. Submits that the matter was heard in part by other coordinate bench by coordinate bench of this court. So, therefore, matter may be listed before the appropriate bench.
My lord in court.
In that case, we'll just list this matter before appropriate bench.
Good.
May I please, Your Lordship? I beg to mention item number 14, Your Lordship. I am praying for an adjournment as my senior is under Lordship.
14.
Lordship, hearing.
Lordship, Lordship, I am for the respondent. Kindly a date may be fixed if we are taking a
14. You are Mr.
A.R. Das, Lordship, on behalf of Mr. R.C. Paul.
R.
R.C. Paul on behalf.
R.C. Paul. Mr. A.R. Das, learned counsel appearing on behalf of Mr. R.C. Paul, learned counsel for the appellant. Press that matter may be adjourned to adjourned for
Adjourned for today, Lordship.
adjourned for
And maybe list
3
on
weeks.
5th of November,
List
Lordship, if possible.
Mr. So-and-so, learned counsel is present and raises no objection. Prayer is prayer is list the matter after 3 weeks.
May it please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item number 19, Lordship.
19.
Yes, Lordship. Mr. R. Majumdar is appearing in this matter. Lordship, due to some personal difficulties, he is out of station, Lordship.
He was here yesterday.
Today he is out of station, Lordship.
Mr.
R. Deka.
R. Deka, learned counsel, appearing on behalf of Mr. R. Majumdar, submits that Mr. R. Majumdar, learned counsel for the petition, has some personal difficulty today, for which he prays that matter may be listed after 4 weeks.
Lordship, may I fix that any day. Any day.
Just after 4 weeks. It is listed today, you are asking for adjournment and then you are seeking fixed date. Sorry.
May it please your lordship. Item number 15.
15.
Yes, your lordship. I pray on behalf of the respondent counsel, Ms. B. Chaudhary. She is unwell, your lordship. May the matter may be fixed on 29.
On the ground that Miss M.S. D. Chaudhary, learned counsel for the respondent, is not keeping well. M.S. So and so.
Ms. B. Chaudhary.
Your name?
My Ms. Julie Das. J. Das.
Miss M.S. J. Das, learned counsel, prays for and is granted.
The matter may be fixed on 29.
Prays for listing matter. Prays for adjournment of the matter for 2 weeks. Pray the law. List this matter after 2 weeks.
Well, item number 19 was mentioned, my lord. My name may be recorded on the matter. 19 may already mentioned.
Your name?
Name may be recorded.
S.K. Mehdi, the great learned counsel.
My lord, only my lord, this another matter is fixed on 13, my lord. 13.
He's present, you just say. S.K. Mehdi. Then it's CGC.
Yes, ma'am. On 13, my lord, the matter is fixed another.
But I'm really very sorry, Lordship. Item number 20 already been mentioned, Lordship, by other side, Lordship. But the thing is that we have listed by order, Lordship.
Then
they mention it today, just before sometime they inform us, Lordship.
it's okay.
Lordship, can it become a first week of November, Lordship?
Already passed the order. You mentioned that day. When the matter is not listed or if it is listed.
Lordship. May it please your Lordship.
Yes.
Lordship, I beg to mention for listing a petition for Monday, Lordship. Admission matter, Lordship.
Let's be listed.
Obliged.
May it please your lordship. As per last order, I could not
Yes.
communicate with my client. So whether she had
What is
submitted,
this,
I
yeah?
have informed her. So I could not get back whether she had submitted or not. Just give me 1 week's time so that I can appraise honorable court whether she had submitted the original or not.
Your client is really interested to get this.
Yes, lordship. She is a
then-
person with disability, lordship.
Then
This morning I tried. Her mobile was switched off. Otherwise, I would have.
on 30/09.
Yes, lordship. Yes, lordship. And I was
Almost a
also.
month back.
Yes, lordship.
It's for your
And
interest.
in between holidays were there and I was out of station, lordship.
It's for your interest only.
Yes, lordship. I can understand, lordship. Just a week's time, lordship.
Yes. Any? Which court AG?
Lordship, I'm appearing on behalf of R.K. Talukdar AG. We have no instructions.
You are for AG?
Yes, Lordship.
Of course, unless you submit this.
She had submitted the required documents, whatever was required at the time of when the application was submitted. She has submitted all the documents. Thereafter, subsequently, they wanted the death certificate of the mother. That also she had submitted.
This PPO.
PPO original, I have communicated to her.
PPO issued to the mother of the petitioner.
Mother, it was not issued to the mother. Mother died prior to the death of the father. And she is claiming pension of her father.
It's okay, but then it was issued to the mother.
Not mother, lordship.
Then why this has been recorded? The mother?
On that day, my colleague was there, but it was not mother. It should have been father. Because her mother died, because in an additional affidavit I had brought in her mother's death certificate.
Anyway,
Acknowledgement.
on the
received.
prayer of learned counsel for MS. On the prayer, Miss MS.
D. Ghosh.
D. Ghosh, learned counsel for the petitioner. List this matter after 3 weeks.
1 week, lordship.
Why?
Because meanwhile, I'll get the instructions, lordship.
1 week. So as to enable her to obtain instruction as the learned counsel for the petitioner is supposed to approach the concerned treasury officer within a week's time from the date of order of this court dated 3009/2024. With regard to the deposit of original PPO issued to the, we'll say father of the petitioner.
Yes, Lordship.
Issued to the father of the petitioner. Father or mother? It's recorded as mother.
So
Issued to
for
the mother of the
husband-
petitioner. You cannot change it.
Yes, Lordship.
This after it.
My lord, in this case, my lord, I have received the instruction, my lord. I'd like to file an affidavit, my lord.
What is the matter, sir?
Matter is about regularization. They are claiming regularization, my lord. Although they were ad hoc employees, my lord.
What is
They're already getting the benefit, other benefits, my lord.
what is
After
your stand?
saying is that, my lord, they're already getting the benefits of the finance department notification.
Minimum.
Minimum, yes, my
Minimum
lord.
pays.
They cannot get the both, my lord.
Minimum pays.
Yes, my lord.
Lordship, in this case, we engage.
Read petition dismissed.
Lordship. In this case, we engage learned senior counsel R.P. Sharma sir. Today he is not able to appear here. Therefore, kindly adjourn the matter for today.
MS
R.
R.
Doctor.
Dr. Learned Counsel for the Learned Counsel submits that she is engaging the Learned Senior Counsel in this matter, for which she prays for listing the matter after 6 weeks. List of praise allowed. List after 6 weeks. In the meantime, the respondents may file their response.
My lord.
Affidavit is not required,
My lord.
Nice.
All right, sir.
but you file it.
Yes, yes, I'll file, my lord.
You have the,
My lord.
you have
All right.
received the instructions.
May I please, Your Lordship?
Yes,
Lordship, this case arises out of an order of a family court, my lords.
yes.
Family Code 3. Lord, the impugn order is challenged on 2 grounds, my lord.
Yes.
First of all, that the evidence was allowed. The erroneous evidence was allowed at a much belated stage. This being the first ground. Second ground, my lord, for allowing this evidence, there was no any reason given. Is it page number 147?
It's trial is concluded.
No, no, trial is going on.
Ah.
When we were about to cross-examine basically the divorce petition was filed by the
4
respondent
mobiles.
before the family court.
4 mobile numbers.
4 mobile numbers, my lords, and
Yes.
then they are trying to annex some evidence, which, my lords, are erroneous in nature. So therefore, my lords, these 4 mobile numbers are new in.
Sir,
First of all,
if it is erroneous, you have to report that.
My lord, the reason I'm saying so, because, my lords, who have challenges is because the manner in which they try to bring in evidence. My lord, because there are parallel litigation also, which is going in DV court also, and also in family court.
Where is the bar to bring an evidence which may be erroneous?
My lords, because the manner in which they have brought it, my lords, at the stage which they have brought it, I'm ready to argue this matter at length, my lords, because of the order that has been passed and without any speaking, the order that is not speaking, my lords.
You argue.
Yes, my lords. But before that, my lords, they have not filed any reply. My lord, if that is not in constraint, my lords, I'm ready to argue this matter.
It is a civil revision. What reply is needed?
Yes.
All the things are on the record. And my preliminary objection is, Your Lordship, his petition is kindly be seen under section 115, read with section 151 and section 19 of the Family Courts Act.
Yes.
According to the Family Courts Act, this is the exclusive, there is no provision of filing revision. Only provision is filing appeal. That too, that will go to the division bench. Kindly, Family Courts Act, section 19. It is not maintainable. Section 19. SAVE has provided in subsection 2, and notwithstanding anything contained in the Code of Civil Procedure or in the Code of Criminal Procedure or in any other law, an appeal shall lie from every judgment or order not being an interlocutory order of a family court to the High Court, both on facts and on law. No appeal shall lie from a decree or order passed by the family court with the consent of the parties, or from an order passed under Chapter 9 of the Code of Criminal Procedure, provided that nothing in this subsection shall apply to any appeal pending before a High Court or an order passed under Chapter 9 of the Code of Criminal Procedure before the commencement of the Family Courts Amendment Act 1999. Every appeal under this section shall be preferred within a period of 30 days from the date of the judgment or order of a family court. The High Court may, of its own motion or otherwise, call for and examine the record of any proceeding in which the family court situate within its jurisdiction pass an order under Chapter 9 of the Code of Criminal Procedure for the purpose of satisfying itself as to the correctness, legality, or propriety of the order, not being an interlocutory order, and as to the regularity of such proceeding. Except as aforesaid, no appeal or revision shall lie to any court from any judgment, order, or decree of a family court. 6. An appeal preferred under subsection 1 shall be heard by a bench consisting of 2 or more judges. So this is the specific provision. This is an order. So no revision lies.
Impugn order is an interlocutory order.
No. No interlocutory order.
What is this?
This is absolute order, Your Lordship. Order has been defined. Yes, very pertinent question. Supreme
Is
Court.
it an interlocutory order or is it not?
It is order. Order has been defined.
Is it order interlocutory or is it not?
No, it is not interlocutory
Impugn
order.
Let us see. What is this? Page
143 to 147, my lords.
1.
43 to 47. 47 is the operative portion, my lords.
No, no.
44 to 47, my lords.
Both the parties are present. No. Today's fixed for order on petition number this filed by the petitioner on 24 January 2024. Saying the petition number this filed by the petitioner praying for permission to file and exhibit a certificate under section 65 of the Indian Evidence Act 1872 as to exhibit for contents and to produce the electronic devices, this being under lawful control of the petitioner, upon which said contents were received by the petitioner, sent from the respondent to prove by way of additional evidence on affidavit by PWs. The respondent has also filed a written objection to the petition number this, wherein she has stated that it is not clear from the application as to what the petitioner wants to exhibit as evidence, and that to exhibit an evidence FC civil case number this much under section 151 of CPC and section 65 of B of the Indian Evidence Act, read with section 14 of the Family Courts Act, is not maintainable, and section 151 of CPC can be invoked only when there is no alternative remedy available. It is further stated that there are pending litigation between petitioner and the respondent in various courts, and during the course of the proceeding, the petitioner had tried to put different statements, and in the course of the proceeding had stated about electronic evidence, and eventually found out that there are many shortcomings, which the petitioner became aware during the cross-examination in DV case number this much. And in order to bridge the lacuna, the petitioner has come up with this application. The respondent has also stated in her written objection that the petitioner had filed his evidence on affidavit as DW1 and on this much in DV case number IMA. He was cross-examined and discharged. During cross-examination, the petitioner admitted of having furnished the Xerox copies of the messages sent by the complainant respondent to him which were Exhibit A to D and were received in his mobile. The petitioner admitted of not exhibiting his mobile phone as material exhibit with his evidence on affidavit. The petitioner admitted of not furnishing certificate under section 65B of the Indian Evidence Act, along with Exhibit A to Exhibit D. It was only after the cross-examination of the petitioner as GW1 he came to know that a certificate under section 65B of the Indian Evidence Act is mandatory.
Yes.
This is the matter of judicial magistrate first class. He has stated in the objection. Judicial magistrate first class where DV domestic violence is now thereafter. The respondent the respondent stated that the present application filed by the petitioner is to fill up the lacuna, and a similar application under section 311 of the CRPC by the petitioner in DV case number Iman to permit him to file and exhibit. Your Honor, he has stated only the exhibit. Thereafter, the last paragraph kindly be seen of that very. The respondent has further submitted that since the screenshot has been submitted and some selective messages have been annexed by the petitioner, it is difficult to ascertain the genuineness of the same. It is further submitted that by showing selective messages at the stage, whose genuineness may not be known, will cause harm and prejudice to the respondent, and further submitted that none of the contact number mentioned belongs to the respondent, and thus prayed for rejecting the prayer made by the petitioner by petition number, as it is devoid of any merit. Heard would the parties on the last date fixed peruse the case record. On perusal of the materials of the case record, and after hearing both the parties, I am of the considered opinion that there is no force in the objection made by the respondent to the above mentioned prayer of the petitioner, and there is no bar in allowing the same, and thus I deem it fit to allow the prayer made by the petitioner by petition number M for proper adjudication of the case. Accordingly, petition number Iman is disposed of, fixing 6/9/24 for filing additional evidence by the petitioner. And on that very day, I filed the certificate. Only section 65B is mandatory. Now, your Lordship has rightly put whether section, this Family Courts Act, your Lordship, clearly states that those words which are not defined here shall be section 1 of the Family Courts Act. Section 1. All other words and expressions used but not defined in this act and defined in the Code of Civil Procedure shall have the meanings respectively assigned to them in that code. Section 1. So, the word Lordship, order has been defined under section 2, subsection 14 of the CPC. That what is the order? Section 2, subsection 14 of the Civil Procedure Code.
Read it. Please read it.
Yes, Lordship. Order means the formal expression of any decision. Formal decision of a civil court, which is not a decree. It is not a decree. It is a decision. Now, your Lordship has pertinently raised one question, interlocutory order. Your Lordship, referring the Apex Court judgment, the Punjab and Haryana High Court, though that was a criminal matter, still then it has held. The expression interlocutory order has not been defined in the court. The said expression was, however, interpreted by the Supreme Court in Amarnath versus State of Haryana, AIR 1977, Supreme Court, 22 page 85, for the first time in these words. Decided cases have laid down that interlocutory orders to be applicable must be those which decide the rights and liabilities of the parties concerning a particular aspect. It seems to us that the term interlocutory order in section 397(2) of the 1973 Code has been used in a restrictive sense and not in any broad or artistic sense. It merely denotes orders of a purely interim or temporary nature, which do not decide or touch the important rights or the liabilities of the party. Any order which substantially affects the rights of the accused or decides certain rights of the
It's okay.
parties cannot be said to be an interlocutory order.
It's okay. What do you mean by it? What do you say now?
Now I'm coming. It is
Don't come, directly come. Is it an interlocutory order or is it not? You just,
no.
why?
Now I'm coming. Yes. I'm making it. Yes.
Defined by the.
Yes.
Supreme Court.
Because that would be against the very object which formed the basis for injunction of this particular. Thus, for instance, orders summoning witnesses, adjourning cases, passing orders for bail, calling for reports, and such other steps in aid of the pending proceedings will no out amount to interlocutory orders, against which no. But orders which are matters of movement and which affect or adjudicate the rights of the accused or a particular aspect of the trial cannot be said to be interlocutory orders so as to be outside the purview of the regional jurisdiction of the court. So, Lordship, it has been made that any order which touches the rights and liabilities of the parties is not interlocutory order. Only, say, issuing the process, recalling it, giving the adjournments, all those are interlocutory orders. So it is a formal decision which are touching the
Rights and liabilities of the parties.
yes, that's it. So it is not an interlocutory order.
Therefore, it is hit by section 19.
19 Lordship. That is my respectful submission.
I'm so sorry. Malad, this is a petition which is filed under section 115 Revit 227 of the Constitution of India. Malad, when he has asked the question of maintainability, Malad, I'm ready to argue on this. Because, Malad, there are judgments. Malad, this one is judgment, Malad, where did not argue about the maintainability, Malad. This is from the High
Heard
Court.
Mr. will admit it and will keep the maintainability, issue of maintainability open.
Yes,
Yes, Malad.
yes.
Yes, Malad.
Heard Mr.
M. Burman, Malad.
Learned Counsel for the petitioner.
And
And also
RPC.
heard Mr.
RPC.
RPC, Learned Counsel for the respondent, admit this revision petition, list for hearing after 4 weeks.
No,
The
Lordship.
question of maintainability raised by the respondent shall be,
First decided.
no, not first decided. The question of maintainability raised by the respondent is kept open.
Yes.
Lordship, since I shall be out of Guwahati, so can
After
it
4
be
weeks.
fixed on 10th or 11th of December?
Malad.
After 6 weeks.
No, kindly, because on 8th morning I will be back, Your Lordship. That's why I
Are
am.
you here or you are from outside?
No, I am from here, but
It's okay.
no, but
After 6
I
weeks.
have some personal problems as well as various other allied matters
That's-
outside. So
Sir, that's
either
why,
10th or 11th,
that's why, sir, we're fixing it after 6 weeks.
Lordship, then I don't want to direct this matter because it is a diverse matter. And so many petitions,
11,
498,
12 will be more than 6 weeks.
and that is why, Lordship, I have calculated your Lordship version, and that's why I am submitting. That in my absence, if it comes again, it will be dragged and extended.
6 weeks, it is published 1-2 days before.
Pardon?
Lists are published 2 days before.
No, 7 weeks kindly be seen. 7 weeks then, Lordship. Because I will be available and I will place the
If
argument.
we used to mention
7
him,
weeks. Huh? Make it 7 weeks.
but till then the interim order may be
Interim order passed earlier shall continue.
until funded orders. Madam. I'm so obliged, Raj.
No, Lordship, not until further orders, till the next day.
Interim order passed earlier shall continue.
Continue.
I'm so obliged, Raj.
Yes.
Come.
Bird Pujari.
I'm appearing on behalf of Arbor Pujari.
Yeah.
On election code number 1. But my matter is under process, Lordship.
What process?
Lordship,
On
within
6th
2 weeks,
also it was under process.
Lordship, as per his instruction, I'm saying that Lordship, within 2 or 3 weeks, order will be complied with. Lordship. 2 or 3 weeks.
We'll record it.
His submission, oral submission, Lordship.
Non-appears for the petitioner on call. Next paragraph. Mr. Arbor Pujari, learned counsel for the petitioner. Learned counsel for the respondent number 1. Alice contender number 1.
I'm as the on behalf of
Steps are still being taken for compliance of the judgment and order dated
7/4/2022. 7/4/2022.
7/4/2022, passed in WPC 1217 of 2022. Yes, he prays for the 3 weeks time. Considering that the steps are being taken for compliance of this, compliance of the order, judgment and order. Further, 4 weeks time is granted for compliance.
Obliged.
Appeal to purpose. Appeal to purpose. May it pleases your Lordship. Lordship,
Yes.
here the office note dated 15/10/24 shows that AD card for respondent 3 not
What
received.
about
That.
this prepared dusty has
Yes.
not been taken back?
Yes,
by
Lordship,
land?
it was within the holidays. Before that we inquired, it was not ready. So Lordship, now we will take it and take the dusty step, Lordship.
So, Lordship, there was one IA. At the time of admission of the appeal, the court, this honorable court has directed to deposit 50% of the awarded amount, which has been deposited, and I have filed an IA for withdrawal of the same.
We have filed an objection, Lordship, because in this case we are alleging fraud. It was a hit and run case, and
This is for who is respondent number 3?
respondent number 3, Lordship, is
Driver, I think.
respondent number 3, driver of the vehicle, Lordship.
Office note dated 15/10/2024 reflects that Edigan in respect of respondent number 3 has not been received back. It also reflects that prepared dusty steps has not been taken back by the land council for the appellant. MS R.D. Majumdar, land council for the appellant, submits that she would do the needful during the course of the day. Course of the day, within 2 days.
Within 2 days.
Within 2 days. He would take appropriate steps within 2 days. And what is to be done
In
in
six,
his IA?
IA
IA Lordship can-
1693/23.
Lordship, my prayer will be can be taken up
After
with
4
the
weeks, 3 weeks.
yes, with the final
Your
year
Lordship,
after.
the amount has
Wait,
been.
wait for some time, since he is vehemently
No,
opposing
Your Lordship,
it.
in this case.
We'll
that-
hear you. Will you hear you? Will you
No, the
hear and
amount-
determine?
Your Lordship, the amount is lying in the registry.
It's all right.
and I am losing the interest.
No,
And
we are
ex-
losing the interest.
No, I will lose the interest.
They will get the interest. It is the insurance
No,
company which
the
loses the
registry will
interest.
not give me any interest.
Court will give you if you are entitled to
Oh,
go.
you are making incorrect submission.
No.
Then your lordship may pass an order on in that way.
No, this
The
has to
amount
be heard.
deposited shall
Sir.
also carry interest, which
Sir.
will be paid by the
Sir.
insurance company.
Sir, do you think if you say that this on your direction will pass the order?
No, my learned friend is submitting that I will get interest. I am saying that I will lose interest.
Sir, wait for some time. We'll hear you. Since she has filed an
Will it-
objection.
Your
All
lordship,
right. You wait for some time.
I
I have
have
not accepted her objection. Whatever I'm saying is, since she has filed an objection, we'll hear you. We'll pass
It
the
can be-
appropriate order.
but the IA can be heard today itself, your lordship. I lost my husband in the year 2011.
Understand? We'll hear after 2 weeks. Not happy.
Your lordship, my sons were minor at the time when I lost my husband. Now one of my sons attained majority. I filed this IA in the year 2023. It is almost 2024, almost complete. I have
Have
not
you
received a
seen- have you
single
seen-
penny.
Have you
Lordship, they have not gone for
have
any
you
execution.
Check out the list.
Your lordship.
Have you checked out the list? How many all matters are listed every day? We understand. List after 2 weeks for consideration of IA. IA number
1693/23.
1690 of 2023. After 2 weeks.
Well, you're obliged.
Another.
Whatever 6.
Sixth Lordship office note says, according to process server notice upon respondent 2 has been duly served, notice to respondent 3 could not be served and address is shifted to another place. Both are kept and flag X. Lordship
Notice in respect of respondent number 2 is complete.
complete.
Is completed. Please stop. Is complete. Please stop. Learned Mr. MS R.D. Majumdar, learned counsel for the appellant to take press steps for service of notice upon respondent number 3.
Yes, sir.
Here, your lordship, I have filed another IA. IA 787/23.
After 2 weeks for consideration. IA number 1.
7787.
In 2 eyes, it will be listed after 2 weeks for consideration. Huh?
Well, you're obliged.
Lordship, your service has been completed on the last date only. It is supposed to come in the admission column, Lordship.
Service complete. Yeah.
Just for admission, Lordship.
Third MS
S. Todi, Lordship.
S.
Todi, T-O-D-A.
S. Todi, learned counsel for the petitioner, and
Ardev, respondent.
MSR the correspondent. This for admission hearing after 4 weeks.
Much
Obliged,
obliged.
Lordship.
May it please the Lordship.
Yes.
Lordship, we have taken steps in terms of the last order.
Office note dated 22. Office note dated 22/10/2024 reflects that. ID card. And neither the ID card nor unserved notice has returned. Awaits service reports for further 4 weeks.
Lordship, the interim order may be continued.
Entry mode of pass alert.
Obliged.
May I please your Lordship?
Yes.
Lordship, affidavit in opposition has been filed on 22nd of October and that is not on record. So
Yes.
matter may be taken up next week, your Lordship.
This for what?
It's a release application, Your Lordship.
Yes. You are objecting,
Yes, Your Lordship. We have filed one affidavit in opposition.
saying what? Saying what?
Lordship, the contents of
Your
the
Lordship,
petition is not
In the
with me.
trial court, they have not adduced any evidence. Neither they have filed any investigation report. They are simply in the police report, which I have exhibited. The police have given a note that I was driving the vehicle in a drunken condition without any medical report. And I have also examined one eyewitness who was duly cross-examined by the insurance company. Now, for even if I assume that I have contributed to the accident, in that case also I am entitled for 50%. So at least this 50% may be released. And they have filed just yesterday after listing of this matter. And I have filed this IA, they have received the copy on 22/2/2024. In between, 2 times the case has been listed. And third
Why
time
you are objecting? What is your objection?
Lordship, I don't have the contents of the petition right now with me, Your Lordship.
How much amount? What is the amount?
I'm not sure. 17 deposited amount is 50% of 17 lakhs to 2,570. It means
We're allowing it. We'll allow to withdraw.
Lordship, matter may be taken up on Monday.
Why?
Lordship, the IA will be listed by then.
We'll record your objection. What is your objection? Why you are objecting it?
Lordship, I don't have the copy of the IA with me right now.
Who is appearing for the appellant?
Your Lordship, their only allegation is that in the Exhibit 1, that is the accident information report, and in the GD entry, the police have given a note that the deceased were driving the vehicle in a drunken condition. There was no medical report. There is nothing on record. The owner of the other offending vehicle have filed written statement. He has not uttered a single word.
Would it be fair? Because she's seeking for tomorrow. Then in that case,
Tomorrow, Your Lordship.
Tomorrow.
Lordship may take it up tomorrow, Your Lordship.
because tomorrow she may say that I have not been heard. It was not the
No,
objection was
this
not,
objection can be kept on
objection
record.
was not before the court. Still,
Lordship
then
may take
court
it
has
up
passed
tomorrow,
on.
Your Lordship.
But in any case, we are allowing. We are allowing your withdraw tomorrow.
They have the recourse note. If they can recover it from me, if they succeeded in the
No,
appeal.
there's no. I mean, there's no problem. But only the technical. I mean, thing that she said
Okay,
that
it
it's
may be
not
fixed tomorrow.
with the. Or Mr. M. Mandal.
D.
Mandal, then counsel for the applicant, Mr. MS
FN Jaman on behalf of S. Roy.
learned counsel for the opposite party. The matter may be listed
Tomorrow, Your Lordship. 25th.
tomorrow, i.e. 25. Huh?
And that
Whatever you want
that
to-
objection may be tagged.
The objection filed by
Affidavit in
the
opposition.
party. Objection filed by the affidavit filed by the opposite party be placed with the record.
Okay, okay.
May I please, Your Lordship?
Yes.
Lordship, in this matter, we have taken steps, and response dated 23 and 24 says notice has been issued upon response number 5. But it has not been reflected whether it has been received or not.
It was issued on 15 only.
Yes, sir.
Private respondent number 9. Sabhone
You are appearing, huh?
I am appearing for state government, madam.
Okay. Notice
Service
has been
I think
issued.
not complete.
Notice for service of service of notice upon respondent number 9 has been issued on 15/10/2024. The list the matter after 4 weeks.
Interim is there, Lordship, that may be complete.
Interim order plus earlier shall continue. The respondent, Mr. T.C. Chuti, Learned State Council may file his response in the meantime.
Obliged.
Yes.
I'd like to call in the last question. Your Lordship, while dictating the judgment, my friend Lordship, Mr. S. Dotto, Senior Counsel Lordship, he wanted to verify whether it will be an appeal or revision against the order of dismissal.
It will be an appeal, my lord, because finally the case was disposed of. Like in whenever there is a delay, appeal is disposed, delay condition petition is dismissed. Appeal also gets here. Then appeal lies against the dismissal. Because appeal is dismissed due to dismissal of the condemnation petition.
Substitution.
Substitution, same thing. It's a case
Yes.
of substitution. Once the petition is dismissed.
Petition is dismissed.
Where is Mr. Doctor? According to it's a appeal is maintainable.
Appeal is maintainable.
Maintainable. Because the whole case is dismissed. So against that Lordship,
So where is this Mr. Doctor? Where is Mr. Doctor?
In any case, Lordship, I don't know, this I have a case, Lordship, that might help, Lordship, this case. In this case, Lordship,
What does it say?
फिर कैलेंडर जजमेंट को दिखाई तो जो अपील है इसलिए अपील वाज ओपन टू
ये तो डिसीजन मेरिट होता है मेरिट होते हैं लाइक
मेरिट इसलिए कंजम्पशन अपील वाज जस्ट अपील
ये तो चल
when appeal was allowed, then that went to the original went to varsity. Claimant died during the appeal. And appeal was only
legal stuff.
maybe
Mr. Datta appeared for whom?
For reliance, no? For respondent number 2.
I'm for respondent number 2.
And Mr. Datta is
Appear for oriented.
yes, for respondent number 1.
Respondent number?
1, because I'm appearing for respondent number 2 oriented.
Regional Manager, Reliance General Insurance Company, Division Oriented. What about these other respondents?
Notice that has already been served.
Already been served.
I inform Mr. Senior Counsel, Mr. Yes, that he is coming.
Yes. Yes.
What is your ground?
He was the deceased lordship. He filed this claim petition before the trial due to accident caused to him lordship. And during the pendency lordship, he expired. Substitute petition was filed by the wife. That was rejected.
Saying that he died
the case
naturally,
is awaited,
not because of the injury caused during the accident.
Because the case was awaited as per the lordship trial court observation. So, substitution.
My lord, my senior Mr. S. Datta, as he is on legs on court 1, therefore he instructed me to take time for after it matter may be taken after some time.
Any judgment you'd like to rely?
So the super judgment is concerned, I have given that lordship regarding the merit of the case lordship. Regarding the merit of the case, your lordship has already done that, so that Supreme Court judgment.
The same judgment I have given now.
Judgment?
Same judgment, Calon.
'86, 2012.
Okay.
Lordship, this is a civil appeal number 4800 of 2021. Oriental Insurance Company Limited versus
Kelon.
Kelon, alias Jesmail Singh Kelon. There are 9, 10, and 20, Lordship.
There are
9, 10, and 20.
It doesn't say anything. 9, 10,
and 20, 20.
So according to you, claim for personal injury will not survive on the death of the injured unrelated to the, but the legal able could pursue the claim for amendment of the claim for loss of the state. This is what you are saying.
Yes.
You are not claiming that the husband died because of the injury.
No, we are not saying.
Your claim will continue to the personal injury caused due to the accident. That is what you want.
My God.
After some time. That's all.
That's all. Your Lordship has already decided to allow this petition.
What decision? What decision?
On the last day, Your Lordship was in a position to some dictation was given.
We'll see.
But in the middle, my friend, Lordship Senior,
We'll hear him for some time.
Lordship has already been heard. Only
Can be.
obliged.
But will dictation will be in the chamber.
My seniors on labs, Your Lordship. Kindly take up after some time.
What to do?
On some other date, Lordship, I'm also not feeling well. Lordship.
2013, man.
Yes, Lordship. But
You
issue
cannot
is,
afford
Lordship,
to adjourn.
if Your Lordship gives this adjudication restricted only to the prayers, Lordship, then it's not a long case, Lordship. It's a small, within a small square. But one earlier order was there, passed in respect of the same petitioner, wherein, Lordship, the state government filed one review petition.
Review petition.
That review petition was tagged along with some other writ petitions. Those writ petitions were disposed of. Accordingly, in this review petition also, it has been shown as disposed of. But this matter was never disposed of.
Yeah.
So that is the, it's a old matter, Lordship. I am not having the brief now. I have already applied for certified copy of the review petition.
That is what you have done last night. Last.
Yes, I have.
But in the meantime, she received one copy, Lordship.
Okay.
I have received.
What does it say?
This copy of the review petition.
Review petition. Copy of the review petition or order of the court?
No, order of the court.
No. It's
What
okay. About the review petition?
Lordship, in the order it is shown as all the writ petitions are disposed of.
Disposed of.
But no mention about the review petition. But as the matter was tagged along with the other writ petitions, same order is shown there also. That is the issue. So Lordship will consider.
So suppose if that means the first review petition has to be decided.
Yes, Lordship.
Is not it?
Yes. That is my prayer, Lordship. Because against the earlier order.
Suppose if a review petition is dismissed,
yes,
then we may hear the.
Then your Lordship will come to the present petition, Lordship.
Yes. If it is allowed.
If it is allowed, Lordship, that earlier decision will go. Then Lordship. But in the present writ petition, Lordship, no such prayer for regularization is there. It is basically a notification of 2012.
Challenging that.
Challenging that
Where
notification.
Where it says
there will be no more regularization and no more creation of
there is put to
supernumerary.
challenge.
But that issue has been.
There is so many writ petitions.
Yes, that issue has been decided.
Decided on what? Saying what?
Ultimately, in WA 45 of 2014, that issue has been. Initially, that notification was set aside by a learned single judge. But before the division bench, that decision was challenged, and that decision was overruled.
Overruled.
So, yes, Lordship. So that.
So that your decision of the government
survive for no more regularization and no more creation of supernumerary posts, that survive.
It survives.
Yes.
The matter ends there.
Yes. That
If
is why I
division
said.
bench had said so.
Lordship, that is why I said if your
Because their
Lordship.
challenge is the decision of the government notification.
That notification.
So that has been affirmed by affirmed by the division bench.
Yes, Lordship.
Matter ends there.
Yes.
But the question
That is why at the beginning.
This petition was drafted by another council, my lord. That prayer I am not pressing because I am not required to challenge the notification. Because my service was already regularized.
Huh?
My service was already regularized.
If it is regularized, why you are here?
They have not paid the regular scale of pay, and therefore, these petitioners, they approached this Honorable Court earlier. This Honorable Court directed the authority, to pay them the regular scale of pay. That order they have, put to challenge in the review petition. Review petition, it is not allowed.
No.
No.
The earlier order was stayed on 28/1/2008 in the review.
You read your prayer.
My lord.
Come to your prayer.
Yes, my lord. I am not pressing the prayer A, my lord.
What is the then? Approved proposal in water for correction of the announcement towards regulation service for purpose release of monthly salary.
That is in my favor, Lordship. If approval is still required, Lordship, then his case was not approved earlier.
Lordship may kindly peruse the judgment of in the earlier order litigation, my lord.
Against that order only, Lordship, the review petition.
That's review petition is
Then,
pending.
let the review be taken up first, my lord.
Review petition pending.
Let the review be taken up first, my lord.
No, so far as this, you have been, your services have been regularized.
Yes, my lord.
Then?
My service was regularized. Now they said that the authority, they question the approval of the finance department. That is why they are, my lord.
Well, the question of regularization, unless it is complete.
That issue has been dealt with by
Suppose
this
your
Honorable Court, my
department
lord.
might have passed an order for regularization.
Yes.
Until unless it is approved by the government,
Yes.
it's as good as not regularized.
My lord, approval was granted, but there was some dissimilarity in these names approval was there. The lordship will kindly turn to page 59 of the petition. Page 59.
Are you still working?
Yes, my lord.
Working but as a master role.
Master role only.
Yes.
And
They are
now,
paying us the master
now
of
he is
service.
getting minimum of the pay scale in terms of that WA45 of 2040.
WA45.
Division based judgment.
You are getting the minimum pay
Yes,
scale.
yes, that we are getting.
Then what else you want?
My lord,
You are master role worker.
my lord, I was a master role worker. My colleagues, my
What
lord,
is now?
Oh,
who were appointed prior to 1/4/1933.
What are you now?
And my lord, I am still a master role worker.
Regularized master role.
Regularized master role.
No, he claimed his service was regularized,
Ah.
but he was.
No, once you are regularized, you
Yes.
get all the benefits as that
Yes,
of the
yes,
definitely,
regular
but-
employee.
but-
But as a master role worker,
Not.
unless you are regularized,
Lordship,
your
one-
minimum pay scale is you are getting the minimum
now
pay
Lordship will
scale.
kindly turn to page 41. 41 is the order whereby our services were regularized.
Yes.
Page 41.
Hmm. Ah,
Consequent upon creation of grade
who
4
had been
post,
engaged prior to first so are still working continuous without any break are hereby regularized. We have
Yes.
to the until further order subject to the following terms in post the person will be to the then
the post against which our services were regularized, my lord, it has been retained at page 45. Page 45.
Hmm.
The post were retained.
Hmm.
Then, my lord, as the regular scale of pay was not paid to the petitioners, they approached this honorable court. This honorable court directed the authority, my lord, to take rectify the mistakes and pay them the regular scale of pay. Page
regular scale
59.
of pay what?
Page 59.
As a regular
Regular
employee.
Grade 4 employee.
How much?
As admissible as per their
No, according to you, how much?
my lord,
Lump sum, gross.
it will, my lord, in the regulation order, my lord, it is reflected the
Yes.
scale of pay.
Hmm.
2,450 so and so, my lord. This is the pre-revised scale, my lord.
Yes.
And page 59 of the direct is the direction of the Honorable Court, my lord.
59.
Yes, my lord.
How many petitioners?
5 petitioners, my lord.
Yes. 59.
My lord.
Yes.
From second
This
paragraph.
this order is under review.
Yes, my lord.
Yes.
Page 59.
Yes, my lord.
Yes.
Page 59.
Yes.
Yes, yes.
Earlier.
State has filed a review.
Yes.
Only the finance department, my lord, not the other departments.
No,
Yes,
we
my lord.
filed
There
a
is
part
review,
of the- part of this.
but the transport
No,
department has
there
already
is a-
filed one affidavit.
there
It's a detailed affidavit, lordship.
Okay.
If your lordship goes to that affidavit, lordship, everything will become clear.
So, can I take up the review? Review is listed.
That will be my prayer, lordship. Lordship will, if
You are basing on this.
Yes.
Well, I think we'll have to see. the
no,
review.
lordship, that is why I submitted at the beginning, lordship.
Yes.
If this adjudication, your lordship prefers to keep restricted only to the prayers, lordship, then nothing remains, lordship. It is an already decided issue. But if that judgment comes into play, lordship, then lordship will have to go to the review petition.
Review petition
No,
also may
it's-
take
it's
because
first-
the review
I think
petition.
first prayer, it may not survive now because they have challenged the 2012 notification.
The second prayer is in my favor, lordship.
Okay, third prayer at least.
Third prayer, it is also not prayer for regularization. Lordship, may kindly see it. To release the monthly salary.
In the scale of pay.
Question of releasing monthly salary, regular salary will come only if his service is regularized.
It has been regularized, my lord.
Yes, sir, this is duly approved by government for regulars, though a mistake had crept in this.
Second prayer, he is praying for approval.
corrected and the matter is engaging the attention of the defects of the case also point out that the mistake that has occurred is correctly mistake in the hand of the in such a thing the report is revised names of the president. I think we'll have to decide the review.
Yes, sir.
Because you are basically based on it.
Yes, my lord.
What you are saying is you have your services have already been regularized, but there was some mistake.
Yes, my lord.
Which stated to have been admitted by the department.
Yes,
There
Lordship,
is some
Lordship,
collective
Lordship.
mistake.
If I am clear, Lordship, if
Transport
Lordship
department.
comes to prayer 2, here he is asking for approval from the finance department.
Yes.
That is what we have stated in the review petition,
But
that
in
his
this
service,
case, in the 4759,
yes,
which is under review.
yes, in that
Court
case it
has
is under
directed
review.
you to
So my prayer will be,
correct,
that judgment
mistakes.
is already there. That judgment is already there. This petition has nothing to be decided. In this petition, nothing is there to be decided because 2012 is already upheld by the division bench.
So he's not.
So
present
Lordship
there.
will decide the review petition.
Yes.
If the review petition goes his favor, Lordship, then that judgment.
Then
Yes.
consequential.
Yes, ma'am.
First, we'll have to decide the review.
My lord.
Yes. Are you ready for review?
Not today, Lordship. Let me also have a copy of the review petition, Lordship. That certified copy I have already applied,
Because
Lordship.
my lord, the review petition is not maintainable.
No, it's okay.
It is not
He-
maintainable
he's
because my
taking
lord,
some time.
all the departments have not approached this noble code.
Doesn't
Only the
matter.
finance department.
One will be suffice.
140 will.
Perhaps not, my lord, because well, this noble code
One
held.
will decide.
This noble code already held.
He will take that stand in
number
the
of
review
cases.
petition, Lordship.
We'll see. We'll see.
My lord.
Keep it yourself for the day. When? Next week?
Not next week, Lordship. In the meantime, I will again approach the registry, Lordship. Because the file is in the court, Lordship, they are unable to give me the certified copy, Lordship. That is the issue. If it is returned to the section, Lordship.
Do we have the review, the brief of the review petition?
No, Lordship. That is why we filed for certified copy.
You don't have that. You have filed the review petition and
In
you
the
don't
year
have the brief.
2008, Lordship. It's a long pending matter, Lordship.
Heard Mr.
ISA.
ISA, learned counsel for the petitioner. Also heard Mr. P. Naik, learned standing counsel for finance department. And MS
MD Bora.
MD Bora, learned standing counsel for transport. Inland water and transport.
Ma'am.
IWT, Inland water and transport department. On 19/09/2024, on the prayer of MS Bora, the standing counsel, matter was adjourned so as to enable her to obtain the copy, certified copy of the review petition
Lordship, I have received.
filed by the finance department, as well as the affidavit filed with the IWT department. Today, she submits that she has already received the required documents. However, Mr. P. Naik, learned standing counsel, submits that. Because that day, which is P. Nair?
I'm P. Nayak, Lordship.
Nayak or Nair?
Nayak, Lordship. It is wrongly written as Nayak.
Yes, that's what I'm saying. However, Mr. P. Naik, learned standing counsel, is yet to obtain the copy of the review petition filed by the finance department, for which he prays for some time to obtain the same. Next prayer. Considering the prayer made in the petition and the and that the review petition filed against the Page 59.
Page 59, my lord. 4759 2007.
Review petition. The 57 of 2009. While review of the order dated 19/11/2007 is pending. Is pending for consideration. As on that. The Learned Council for the Learned Standing Council, Mr. P. Naik, granted for that 2 weeks.
Lordship may kindly make it 3 weeks, Lordship.
3 weeks.
This is a method of 13.
Obtain the required documents.
Well, the transport department has got the copy.
It's
Now,
all right.
my friend can keep the copy from transport department.
I have already applied, Lordship. In the meantime, I will again place one reminder. Lordship. I will get the
It's okay. Then we'll after 2 weeks we'll decide first.
1/7.
The review petition filed by the Finance Department shall be heard and considered on the next date fixed, on the next date of this thing. Just after 2 weeks. 2 weeks we'll decide.
Well, review petition along with the writ petition.
It's passed in the writ petition. Right. In writ petition. Then this order will be in the writ petition. The matter after 2 weeks along with review petition number 57 of 2009.
Lordship.
Instead of that, Lordship may direct the registry to list the review petition along with the writ petition. Let the review petition be listed along with the writ petition, my lord. That will be better, my lord, if because already the review petition is there with the record of the writ petition. Today also it was there.
List along with the review petition.
No,
passing in order.
It will be more appropriate if the review petition is listed.
Yes.
I've said it will be taken up. Review petition will be taken up. Anyway, either way.
Otherwise, it will be listed in the same way, my lord.
No. In any case, whoever takes up the matter, they'll understand unless the review petition is taken up. Writ petition cannot, because
Again,
your basis is now
that order of 2005.
lapse of time. Your basis is that order only.
Yes, ma'am.
2009
Yes,
7 order.
Of
So it is under review. Yes.
My lord, this appeal is filed for enhancement. There are so many grounds that we have filed as appeal. My lord, first of all, in the tribunal, some exhibits which are exhibited as an expenditure of medical treatment was not in dispute, but it was not considered. Then after, my lord, I have submitted exhibit number 52, 57, 58, 59, 60, which are, my lord, regarding the disablement of my handicaps. My lord, I was in neurological, there was a neurological disorder against me, and the same was proved by the exhibit number 51. My lord, regarding that the disablement, there was filed the chief psychological doctor, which is exhibited, and affidavit is filed by the Dr. Nimi Bargohai, my lord, which is kept in the record. My lord, on the same documents, I was appeared before the medical board, not Lakhimpur. I was examined, and I was also and doctor as a CW5. He was examined, and it was proved that due to that accident, I was a neurological disorder, my lord. I was a patient of remote memory. There is an test report filed by the Department of Neurotherapy GNRC, which is also exhibited as Exhibit 51. The test of findings was that, my lord, remote memory was poor, recent memory was inadequate, action and concentration is poor, immediate recall is inadequate, recognition is also inadequate. The same was examined as a CW4, Dr. Brijen Bihari Day. In his cross-examination, he also reports that I was a patient of my lord, yes, my lord. In his cross-examination, he also stated before the Honorable Court that from the records available with GNRC, the patient came to check up on 19/10/11 and he was found to have confusion. He again came on 7/1/2012 and he had difficulties in walking and had headaches and dizziness. The patient again came on 10/3/2013 and he was found of confusion, and again he was come again 29/9/2012. The patient was came to GMRC to check up and he was also found to be confusion. So, my lord, from the date of the accident, I became a mental disorder person, my lord. Again, my lord, we had filed an application before the district medical board, and Dr. Jatindranath Madhav, he was also examined, and he also placed before the stated before the honorable tribunal that the certificate issued by the medical board after examination of Loban Vishwakarma, the medical board agree with the opinion of the Dr. N. Buragohain, senior clinical psychologist. My lord,
How much you have been awarded?
my lord, my expenditure was 2,50,000.
Yes.
And the expenditure voucher was exhibited. The exhibited was not in disputed, but only from the expenditure, rupees 2 lakhs was awarded. 5,000 is given only pain and suffering. The disable certificate are not considered. And I am the became a person. I was the person of a skilled labor in Satyam Ispat Limited, Bandardua, and I was paid 7,000.
Because of the accident
Yes.
injury,
Yes, my lord.
you become disabled.
Yes, my lord. Yes, my lord. The documents I have submitted, which is duly proved. My service was terminated. The same document is submitted before this honorable court by exhibit number. Yes, exhibit number 60. So my service was terminated due to the disabilities. Therefore, my prayer to this honorable court is that I had two children. I have a mother-in-law. I have a wife, and my service also terminated due to the disablement. Therefore, as per Rajesh versus Rajveer judgment, if the avocation is lost, then 100% loss of income has to be awarded.
Was it been proved
Yes, my lord.
before the tribunal?
Yes, my lord. I have exhibited all the documents. Service termination
Exhibition,
letter.
exhibition is something different. That proving
Person is also
another thing.
examined, my lord. The person who issued my
Has it
salary
been,
certificate.
has it been proved?
Yes, my lord.
Where it is?
My lord,
Where is the findings on that? What is the finding of the learned tribunal on that?
my lord, as the judgment, in the judgment, the disability was not considered only on the ground that the claimant, injured person, was not appeared before the court. In the judgment itself says. But my lord, I had filed a petition. Yes, I had filed a petition on 10/11/10/2012. White petition number 682/2012, that due to the mental disorder of claimant, his wife Parvati Vishwakarma filed a petition that evidence has to be filed by me. Allowed to?
Sorry, no head and tail.
My lord. My lord, my submission is that, my lord, the disability certificate was not considered, and it has to be considered because of the learned tribunal rejected the disability of certificate only because of the injured person was not appeared, but it was on permission of the court. The wife of the injured was given evidence. The grounds of rejecting the disability certificate is in the judgment copy itself says that.
Where it is?
Yes, in the judgment copy itself says, yes, my lord.
There are, is only one line judgment, or is it consists of how many pages? How many paragraphs? Show us particular the findings which you are attacking.
Yes, my lord, in the judgment copy.
It's very difficult.
Yes, my lord. In the 10, page number 10, in judgment copy. In judgment copy, page number 10. Here is written that, my lord.
Where it is?
Yes, my lord. So,
Page 10.
in judgment copy, page 10.
Judgment, page number 10.
10.
Of your petition. Of your petition or what?
Not in my petition, in the judgment copy of the learned. I actually, my lord, I have not bring the memo of appeal. I have just said IA copy there.
How can you argue like this? Maintain some decorum and discipline. Without the memo of appeal, why you are arguing? How you can argue like that?
Actually, my lord, earlier, my lord, another advocate was engaged. He has not.
Don't
delivered
tell
all
me
the documents.
either you ask for a time or you don't.
Yes, my lord.
Argue or
Next
you
date-
don't argue.
Next that I will take all the.
So I'm
copies.
saying it's no head and tail. How do we decide? How do we determine? Whatever it comes to, you are just spitting it out. That's all. No head and tail. I'm sorry.
My lord, given one. After three weeks, 4 hearings.
Don't do like this. It's not good for everyone's health.
Yes.
Including yourself.
Yes.
The most affected person will be you. On the prayer of Mr.
B.R.
Huh?
B.R. Das.
B.R. Das.
Yes.
B.R. Das, under counsel for the appellant, list this matter after 3 weeks. As the learned counsel has attempted to argue the matter without having a brief list of such conduct, it's not appreciable. Should I say more? Anyway,
He's coming, I can start.
Yes.
Lordship, the award for a small amount,
Yes.
but then we have denied, we have filed this appeal because insurance company had reduced evidence to prove that there is no policy.
Is it?
Yes.
So,
In fact, Lordship, in this case, when the insurance company filed a petition under section 169(2), saying that we do not have a policy, please direct the owner to produce the policy copy. This is in page 40 of the LCA, 48. 47, page 47 is the receipt of
this is by appeal by
the insurer.
insurance. On what ground?
Only that there is no policy and yet the award is passed. That insurance company denied the policy, although no such policy was issued to the insurer. No policy, there could not have been an award against us.
Is it?
Yes. Let's see page 47 of the LCR. That insurer owner was duly served. His signature is there. It was served by a Jari Karak. And what?
মানে ডিম টু হিসাব করে অর্ডার
No, order. So he happens. Jari Karak also.
নেন একটু কম কোর্টের অর্ডার আছে ডিম টু হিসাব
Lordship may see also page 48. See? Oh, it's 48 page 2. For 8. 47 is 48. 47 are backside to Nudin Street. 48.
What is this?
It's a record LCR Lordship. Just to show Lordship that the owner was duly served, he had received it. It was served by Jari Karak, who had received his signature, taken his signature. And 48 is the Lordship a direction specifically direct him, is issued by the Lordship, tribunal, directing him to produce the policy. So we have insurance company filed a petition that we have not issued any such policy. Please direct the owner to produce the policy.
What does it say? It's a
Despite that, Lordship, he doesn't come to the court to produce the policy.
No, it's only the notice.
Lordship?
What does it say?
No, this 47 is a notice. I'm talking 47 notice. The backside is the signature of the EA. Backside a report of the EA, Lordship.
It's okay. This has been served, but what it's a
The next page, 48, Lordship.
it's a
Next
normal notice.
Yes, Lordship.
Then
Lordship may come to next page, 48.
yes.
48 is not normal. 48 is, Lordship,
Okay.
insurance company had filed a petition under section 169(2) that we have not received any such policy. There is no such policy in our records. Please direct the insured owner of the vehicle to produce a copy of the policy along with RC and others. So this is a direction of the tribunal directing him to produce the policy. Yet he does not. He doesn't come to the court. He remained expert. Under such circumstances, Lordship, the learned tribunal ought not to presume that there is a policy because we have specifically examined two officers of the court only on this point, Lordship. So we have not issued any such policy. The police had seized a proposal form. That is why the learned member was moved to believe that there may have been an insurance. The proposal form is not a policy, Lordship. Anyone asks for an insurance, he wants to insure a vehicle, he is given a policy, proposal form. He has to fill it up, then pay the premium, then it becomes a policy. There are different policy documents.
What is the finding on that? Have you raised all those issues?
Yes, we raised the issue because that's why the evidence
So
was
11
late.
part is page 12, my lord, paragraph 24, my lord.
That is why these witnesses were examined, this petition was filed.
Yes.
The finding your tribunal lordship in para 24 and 25. May I read, lordship?
Yes. Read para 25.
Yes, lordship. One Xerox copy of proposal form number M so and so is available with the case diary of GR case number, from which it reveals that the policy was issued by Cholamandam General Insurance Company Limited in the name of Krishna Kumar Barua. The vehicle number is shown as so and so, and the period of insurance was 28/3/16 to 22/8/2017. In the said policy, one seal of Cholamandam General Insurance Company is also affixed, dated 22/8/2016, with the initial of the authority concerned. But the DW and DW2 nowhere denied the signature and seal of the OP number 2. So the insurance company has denied the policy, denied a policy against the vehicle number so and so and the relevant time at the accident. But OP number 2 has failed to show any better document to prove that the vehicle was not insured at the relevant time of accident with OP number 2. Though one Xerox copy of proposal form is available in the CD, but from other documents like Cizalis MBA also reveals that vehicle number so and so was duly insured with OP number 2 at the relevant time. Under such a OP number 2 is liable to pay compensatory payment. This is where what I'm challenging, lordship. This entire understanding of the proposal form was wrong, lordship. It is not policy. I may be allowed to explain, lordship. The proposal form is there.
No, one Xerox copy of proposal form was there, and then policy was mentioned there.
No, lordship. That
And
is where
dates of
that is where, lordship, entire confusion is arising.
It reveals the policy was issued by so and so in the name of so and the vehicle number so in the said policy one seal of in the said policy one
Yes,
seal of
lordship may take up that particular proposal copy, lordship. Lordship, I'll explain to you, lordship. Proposal copy is there in the record, lordship. Exhibit. It's a proposal form. Anyone asks to insure his vehicle, insurance company give a proposal form.
What about this seal and signature?
That seal is there. The proposal they give
In
a
the said policy one seal of so and so is also affixed 28 with initial of the authority concerned.
Yes.
Huh?
That is there. Lordship, I may be allowed to explain. Lordship may come to the proposal form. I will explain. This is an entirely wrong or erroneous understanding of the document.
It's all right, but
no, it's not a policy, lordship.
Huh?
That does not make it a policy. A proposal form is not equivalent to a policy, lordship.
Or in proposal form, this policy was there.
No, this is not a policy. Lordship, please see the document. It's not a policy.
Which page?
Document policy. I'll show the policy. This document, lordship, may see the document and lordship will be
Very
convinced.
strange. You are the insurance company. You have insured the weather and you have lost your paper and saying that.
No, lordship, that's entirely erroneous. I think there is document. Lordship, I will be allowed to explain before I, lordship, draw any. I'll explain this, lordship. It's very clear, very easy to understand, not very difficult. I don't know why the learned member did not understand it. Because the insurance company, two officials would not be irresponsibly coming to the court and say that this is not a document, not a policy. The proposal, yes, no one has denied the proposal. That's an exhibit.
There is some other documents. The record is also.
The policy copy to us. It's there. I'll explain this to you, lordship. This is a standard proposal form of the company. Whenever it is issued, it says seal. The seal doesn't make it a policy document. Lordship may see there is a place called check number. Lordship, a proposal gets converted into a policy only after premium is paid. This man has taken the proposal form and did not return. Had he returned, if he had the policy, he would have come to the court. Court had directly asked him for a policy.
Where is
It's not a general notice, Lordship.
Where is your statement on that?
Cross-examination, Lordship.
Deposition
Deposition, yes.
of your OP number 2.
Lordship may
one
come
or two.
to base cross-examination. Lordship may come to the cross-examination part of it.
Page.
I haven't seen the by no chance, Lordship, it is here.
Yes.
Policy. It's a simple proposal which was not converted into policy by paying premium.
Sir, I've understood, but
Lordship has got the cross-examination.
what is the OP number, deposition of OP number 2?
Yes, Rupam Datta.
Where it is? He is working in the list of coming models which is a list to be involved in the was not duly insured with the number is not liable to be.
Lordship, may I pray, Lordship? A comparison with the standard policy form, Lordship, will make it clear, Lordship. There is a proposal or a policy. I may be allowed to produce a copy of the policy, standard policy for this type of vehicles. The next day, Lordship may compare and find out these two are entirely different documents. It may carry a suit because insurance company.
The ground is that you have said that the vehicle
was not
involved
insured.
in the accident was not insured.
Yes.
However, the learned tribunal has gone on to return a finding
Yes,
that
countries have they thought
since
this is
in
a
the
policy.
form,
Yes.
in the proposal form, there is a signature
That
of
every
the
proposal
company.
form carries, Lordship. Any document goes out of the
Therefore,
company.
it's just in proposal form. It's not a policy as such.
It's not a policy.
So you are the insurer were
Not a
directed
vehicle.
directed to produce
Produce
the
the policy. He did not come before the.
despite receipt of the notice.
Yes.
he did
Adverse
not
presumption
produce.
ought to have been
So
drawn that he
therefore,
doesn't have a policy.
there is no policy as such. Forget about the proving the policy as such.
Yes, Lordship.
Yes.
That adverse presumption should have been drawn. Lordship. I'll cite a Lordship citations not today.
Your Lordship has already gone through the record, my Lord.
Yes.
The learned tribunal has given a justification, my Lord, why he has come to finding that, my Lord, there is a policy, my Lord. It's not a simple proposal form, my
It
Lord.
says it's a proposal form.
It's a proposal form, but
After that, only after completion of the procedure,
my Lord. But they
then
failed
the
to prove that
policy,
there was
policy,
no policy, my Lord.
policy is given.
My Lord, before
And the owner was directed to produce the policy.
My Lord, to the owner, my Lord, I'm helpless, my Lord, because I cannot produce the policy, my Lord. I'm the claimant, my Lord. My Lord, owner, but if the owner did not submit, my Lord, it's a burden of the insurance company to prove that there was no policy at all, my Lord. But my Lord, the tribunal from the evidence of
what is the award amount?
Only
1,63,000, my Lord.
But
They may, my Lord, pay and recover, my Lord.
Injury.
Injury, my Lord. Serious injury.
What is the extent of injury?
Injuries are there, my Lord.
What is the basis of the 160, something like that? What is the total amount?
I'm not in the quantity here, Lordship.
No, I'm just saying. On what is the basis of this 160?
Basis of, my Lord, 163, my Lord. There, it's in page 14, my Lord.
In regard to
Paragraph
non-pecuniary
29, my Lord.
After the exchange, he was invited to
Moreover, in this type of cases, my lord, Supreme Appellate Court has held again and again that, my lord, because of the fault of the owner, my lord, the claimant and victim should not suffer. So they may make the payment and recover from the owner, my lord. Pay and recover principle under principle of pay and recover, my lord. Because claimant should not suffer for the fault of the owner, my lord. That's the principle, my lord.
So pay and recovery cannot be ordered unless there is a policy, Lord. There are very clear Supreme Court decisions of the once there is a policy and there is a violation of the policy conditions. Pay and recovery comes into effect, Lordship, once there is a violation of policy conditions, no DL, no permit, and maybe some other kind of violations. So there, Lordship, in spite of the existence of a policy, there is violation. In that case, pay and recovery. But when there is no policy in existence, we are not talking of any violation at all. Policy doesn't exist. So in such cases, very clear Supreme Court decision, I will be able to cite it, not today, but so to show that pay and recovery cannot be allowed when there is no policy. It may be allowed only when there is a policy. And there is some violation.
He never contested the claim.
No,
That's all difficulty.
That's the problem.
Lordship, even in the proposal form, Lordship, there is a column just above the seal. Lordship may see it is in payment mode, draft, check, cash. That is entirely blank. That shows no premium or something. Why did the owner keep away? Initially, he remained expertise. Then court asked him specifically produce the policy. He doesn't do it.
But
The presumption is heavily loaded against him.
Badmasi appears to be by the owner.
Lordship.
Badmasi.
My lord.
What to do?
It seems small amount, Lordship, the owner can afford to pay. And if
Owner-
a big amount,
if
then
owner
maybe
is not
the
contesting. If
the
owner is
conscience
not-
of the court would have been
not before-
pardoned.
Neither before the tribunal nor before this court. Have you made him a party?
Yes, my lord.
Yes, he's a party.
His party.
Notice is served?
Yes, service complete. R1, R2 file a column number. R1, R2 file a column number.
This who is the owner?
Owner is respondent
Krishna
number 2,
Kumar
my lord.
Bora.
Krishna Kumar Bora.
Huh?
Krishna Kumar Bora, respondent number 2, my lord.
R1 and R2 has been duly represented by learned counsel by filing Wakalatnama. Who is this?
আই হুসেন নেকি আই হুসেনটো আপোনাৰ লগত নাই আই
Krishna Kumar appear কৰিছে। I was in, as per record,
Kumar
Lordship,
Bora.
1 and 2 file local number.
Who has filed this? Find out with this lawyer.
I Hussein.
Respondent number 1, P. Chundi.
Yes, my lord. That's me, my lord.
It's you. I. Hussein and L.R. Majumdar.
Huh?
Can you find him out?
To try, my lord, I don't.
Because prima facie,
My lord.
it was not true that there was a policy or not. The tribunal had only taken the proposal. At the same time, it's an accident. I mean, motor accident claim. Just don't want to be. It would be hurts and injustice to the
Yes, my lord. That's
claimant. But at the same time, privacy, after hearing you and looking at the, the documents, there is no policy.
But if the owner is it's directed by the court to make the payment, my lord, then in that even, my lord, I may have some recourse to
No,
get the money,
Small
my
amount
lord.
you may pay up also,
My
very small
lord, but
amount.
No, that's why.
That count,
You get hold of this.
my lord.
We'll take it up next week.
My lord, I will try to find it out, my lord. Who is
Not
doing
try.
that.
You find him, catch him on.
Yes, my lord.
Because he has filed in Bakalatnam. He just cannot.
Run away, my lord.
Run away.
My lord.
It's a power. Power has given to
Yes,
him.
my lord.
So you find it out. Both of you kindly.
Yes, yes, I'll do it.
It's your ethics also. It's your professional ethics also.
My lord.
It's not. It's a one matter, but then you just cannot afford to do that. Yes. Otherwise, it's very difficult.
My lord. No, my lord.
Anything else?
Yes, my lord.
Anything else you want to say?
No, my lord. That's all, my lord.
Because records clearly says so.
But the tribunal has held, my lord, from those records, my lord, came to a
but
finding that, my lord,
that's
there
why-
is a policy, my lord.
is
That's,
I
my
mean,
lord.
prima facie.
Prima
I'm
facie.
yet to finally determine.
My lord.
But prima facie, I mean, tribunal was wrong.
Because without, my lord,
Because
the
this is
policy
a
being there, my lord.
clearly proposal. Just look at this.
My lord. That I have seen, my lord. But the court has come to a finding that the policy, there is a period of that
It's a
policy
form,
also,
form
my lord.
only, proposal form.
My lord.
After this is built up and this is done only completed, then only policy is
Yes, my lord, that's true. But
the
the
policy for that also you have to pay
my lord.
certain premium and all those things. It appears
Yes,
to be not that thing.
my lord.
That's why I said
My lord.
repeat. I mean, I'm repeating.
My lord.
Badmasi is by the owner.
My lord. That's true.
He has just given it to the police only. This is from the police record only,
Yes, my lord.
not even from the insurance
My
office.
lord. It's from the police record.
And he decided not to appear. So
Next week, my
next
lord.
week, next week,
Next week, my lord.
heard Mr. And so then contact with the appellant and also Mr.
P. Sundi.
P. Sindi.
Sundi. Yes.
Sundi.
Respondent number 1.
Respondent number 1. Next para. Mr.
Lulu.
What is this name of that?
I Hussein.
I Hussein, along with him, Alar Muzam.
Mr. I Hussein, Mr. MD I Hussein, along with LR Majumdar, learned counsels, have filed the power on behalf of the respondent number 2 on 30/01/2020. However, they remains absent today during the when this matter is listed for when the matter is being taken up for
30 October.
hearing.
Witness.
31st
Having heard the learned counsel for the appellant and the respondent number 1 at some length
I Hussein. No?
in the facts and circumstances of this appeal, the
Alar Muzamdar was. Alar Muzamdar was.
respondent number 2 is required to be heard. Listen. Therefore, the matter is adjourned for a week. It is the court requests learned counsel for the appellant and respondent number 1 to inform the learned counsel Mr. MD I Hussein and LR Majumdar, learned counsel, who have filed a power on behalf of respondent number 2, and to place their state to make their argument on the next date.
30th October, let's say.
Huh?
Or 30, Wednesday.
It's a Wednesday, not hearing them, my lord. Otherwise, 5th of November, my lord, hearing them. Is it kept part-heard, my lord?
No, we'll just keep it like that.
Okay.
Yes. Yes. Yes, yes, yes. Yes, sir.
I'm sorry I could not be there when it was
It's
called.
okay. What is your view?
My lord, my view is very simple. Your lordship may kindly see at the MP in order, which is at page 38, my lord.
Yes.
The last paragraph I'll read. In the instant case, the accident took place on so-and-so, and in the accident, the claimant's right hand was fractured and subsequently amputated. He died after more than 1 year on 8/5/2017. He was aged about 60 years and died natural cause other than related to the injury. Now, this part of the thing, my lord, I do not know how the learned judge has come to that finding.
Yes.
It might be, my lord, your lordship kindly see, if the injury persists and in course of that injury he expired, my lord, in that case, obviously, claim petition is amenable.
Yes.
Now, here, the finding on the basis of what I don't find.
Yes.
So, therefore, it's a case where I feel
Whether
it should-
he has died or not, naturally,
Yes, yes.
it doesn't have any bearing.
No,
Because
they-
his claim was on the on injury.
Injury.
Sustained to him.
Right.
In the during the pregnancy, he died. Maybe
He died.
naturally. It doesn't
Yeah.
have any bearing on the claim.
Exactly. Now,
So the wife has the right to be is entitled to be substituted.
that part is okay.
Yes.
So far, my lord, whether he is entitled to get, I mean the
No, that
the
will be
legal
determined-
air.
No, that will be determined by tribunal.
Yes, yes, I'm saying that, my lord. It should go
Whether
back
there was
there.
an injury or not, what extent, and
Right,
whether
right.
she is entitled to for that injury sustained
Exactly, my lord.
out of the accident.
Yes,
That is something different.
So it will
But
go
not
back,
deciding it.
my lord.
Only the reason that he has died naturally,
Right.
therefore she cannot maintain and substitute the disease.
Right.
I think it would not be proper.
Yes.
So remand it back.
Yes,
Allow
yes.
her to be substituted.
Exactly
Clearly
that.
says so.
My lord.
But the issue was, since this is the claim, the claim petition has been dismissed on the ground that the petitioner could not have substituted.
Yes.
Whether this is applicable or not, that is the legal issues which we have,
My lord,
which we have encountered last occasion.
yeah, right. Is it, in fact, my lord, it's an appealable order.
Your friend also suggested.
Yes, yes.
So we allow.
My lord, yes.
We'll pass the order in the chamber.
Yeah.
We'll
Obliged. Much obliged.
allow, huh?
My lord, I have.
Item 11. You'll have to be at 8 o'clock.
Kali bolun.
You will have to be. MSCP allowed, huh? Yes, sir. Mark it. Item 11.
Obliged.
Chamber.
Yes.
Yes.
My lord, I take your lordship's leave to mention one matter.
Yes.
Item 21-22. My lord, I don't have any problem, but since one part-heard matter is going on in court number 14, my lord, I'll have to be there. So if your lordship can accommodate me for passing over for the day only, tomorrow I'll do it.
Tomorrow it may not be possible. We'll list after 2 weeks.
No, my lord, I am the claimant, my lord.
Let it be tomorrow, my lord, if your lordship
Tomorrow
has
it's
no
not
inconvenience.
Then Monday, my lord.
After 2 weeks.
My lord, actually, I am the claimant, my lord. They are got the stay order, my lord.
50%?
It's a matter.
No.
It's a, you have waited for 2 years.
Yes,
Another 2 weeks will not cause any.
That part is right, my lord. But actually, my lord, I am the claimant. When the case was pending, my lord, subsequently himself filed the case, my lord. Without the procedure of law, my lord, they
Okay,
must be paid 50%. That was not paid, my lord.
After a week.
Then, my lord.
Not tomorrow. After a week.
Date may be fixed, my lord. Otherwise, it did not.
No,
be
after
fixed,
a week, you just list,
Any date, my lord.
You give the date.
Give the date, my lord.
On the prayer of 21, 22. On the prayer of Mr. S. the London Senior Council, and not being objected to by Mr.
H. Ali, my lord.
H.
Ali.
H. Ali. Then council will respond. This matter after a week. On a date. Huh? 14.
Which I'll go to 2 weeks, 1 week, lordship.
Hello, bless.
Make
Much
it
obliged.
13. 12 we have picked so many matters. Hearing day.
Obliged.
16 over.
Please, Your Lordship. This matter
Yes.
pertains to reservation in promotion for disabled persons. Before Your Lordship peruses the record, may I just give a brief of the matter?
Other side is ready.
The government advocate is there in the other side.
Ready?
I'm for response 7. I'm for APSC. I don't have any role in this.
APS
It's regarding reservation.
reservation in promotion for disabled persons.
Okay.
Lordship, here
Why two petitions?
there are two,
persons.
these are analogous
Two
matters.
Same post.
Same post.
Same post, same department.
Same department. Lordship, the matter is like this. The
Ready?
act-
No, Lordship.
We'll hear you over 2 days hearing day. We'll hear you.
Yes.
We have enough, we have enough time to
and
say.
there is nothing much in fact.
Better for the time being.
We'll just hear it.
I-
Hear her. Who is appearing?
The Dean of Lordship, Senior Government Advocate.
Yes, you
He is
inform-
on legs code number 1.
You inform him. Every time she'll start. Yes.
Lordship, the Disabilities Right to Disabilities Act of 2016 provides that 4% of the vacancies in the cadre STEM should be reserved for persons with benchmark disabilities, and these benchmark disabilities defined there in the Act of 2016. And there was a dispute as regards whether these 4% reservation which is provided, it should be applicable to promotion or not. Honorable Apex Court, way back in the year 2016 itself had settled it that irrespective of the mode of recruitment, whether it's direct recruitment or it's promotion, it is this 4% reservation in promotion for disabled persons will apply. Otherwise, it will frustrate the objective of the act for which it has been brought. And in terms of that act, both of these persons, at the time when the writ petitions were filed, they were serving in the post of junior engineers in the PWD department, and they were claiming promotion to the post of assistant engineer, civil in PWD department. The post of assistant engineer is filled up in the ratio of 70:30. Direct recruitment is to by promotion, and they were claiming promotion. They were claiming promotion, and
70% is direct.
Direct recruitment and 30% promotion.
Yes.
That is the mandate of the act, and they were claiming promotion as it is. They had benchmark disabilities in terms of the Act of 2016. They had claimed promotion in terms of the act after the Supreme Court judgment came into being, but the authorities were denying them promotion, were not considering their cases in fact for promotion on the ground that the office memorandum which lays down the guidelines for promotion of disabled persons provides that beyond grade B post, that is in grade C post, there will be no reservation in promotion. That means in grade A and grade B post, there will be no reservation in promotion. That is what the office memorandum of 2019 provided. Accordingly, after no response was received from the authorities, we approached this honorable court challenging that offending clause in that office memorandum. And on the day of the motion day itself, that offending clause, as it is violated the law laid down by the Honorable Apex Court,
Yes.
it was stayed.
Yes.
It was stayed. But thereafter also, these persons were not given promotion. But after 2 or 3 batches of promotions were like made,
Yes.
these persons were given promotion not in terms of the disable, in terms of the this Act of 2016, but in terms of seniority. So they have been so that as we stand today, they have been promoted.
Already
But
promoted.
but
on the
not in
basis
terms.
of the
Yes, on the
reservation.
day when the writ petitions now, what are claimed, the part of the claim that remains is that on the day when the writ petitions were filed, there was a law laid down by the Honorable Apex Court of India, law under 141 of the Constitution of India, which mandated that irrespective of the mode of requirement, the Act of 2016 has to be followed, Section 32, and in accordance with which we were claiming. And also these Honorable High Court had stayed the offending clause, but despite that, they were not given promotion. Thereafter, they have been given in terms of seniority. So what we are now claiming is that our promotions will be effected on the with effect from the date when the writ petitions were filed. At least immediately thereafter, when the next promotions were effected. That is the only claim which remains right now in the writ petition. And as it is, there is a law under the honorable law laid down by the Honorable Apex Court. So they cannot go against the law laid down there. So the promotions have to be given effect with effect from that. If I may take your lordship to writ petitions right now.
Just wait. Before that, the day when you filed the writ petition,
Lordship.
was there any consideration for promotion? Was there any consideration for promotion?
No, because of the OM was there, which mandated that.
Whether there was an existing post whether there a vacancy or not?
Yes, there were vacancies. There were vacancies.
But then since you were not considered,
we were not considered
by applying invoking the 2016 Act, provision
Yes.
of 2016 Act,
We
you
were
had-
not considered.
You had not been considered.
No, we were
Others
not.
were given.
No persons with disabilities were given promotion.
That other normal.
Normal, yes, they were
normal,
given.
They were considered.
They were considered.
On
They
the
were
day
considered.
when you filed the writ petition.
Yes. Yes.
And at the same time, you have to work out the arithmetically. How many
I have
posts were
provided.
there,
I have
according
provided.
to how in which slot you are entitled to be promoted,
I
on
have
which
worked
day the matter was considered. Because reason is very simple.
Yes.
You might have come across, must be aware of that. Recent judgment also Supreme Court. The promotion takes effect from the date of the DPC, not from the date of vacancy.
Yes.
Which you make, anyone can claim. I mean, no retrospective promotion as such. It should be prospective from the date of DPC, not prior to that, even if there was a vacancy, because government, I mean, state has decided not to fill it up. You cannot compel them to fill it up. Is not it?
No, Lordship,
The
yes,
other
yes.
aspect would be
Yes, it's not from the
important.
date of vacancy. No one can claim that the effect should be given from the date of
Even if
vacancy.
you are, even
That
if
we
you are
cannot claim.
eligible, even if you are
Yes,
eligible.
that one cannot claim.
Yes.
Lordship is very much correct. One cannot claim from that date.
Yes.
But if there is a consideration, and here is a case, there is a consideration. After, in fact, immediately after filing of the writ petition, I've given the entire details.
Yeah.
I've given the entire details here. There was a consideration, and there was a law laid down.
Since you don't fall within the zone of consideration
We
in
fell-
the normal course of promotion.
No, even we come under the zone of consideration.
Zone of
also.
consideration, but then there will since a limited vacancy.
Yes.
In view of this, I mean, below in the seniority list or whatever.
Yes.
I mean that we call
That-
it.
that
Let us
was-
call it a normal
Yes,
proceedings.
yes.
Normal proceedings.
Yes, yes.
You could not be considered.
Yes.
Had you been considered invoking the provision of
Yes, yes.
2016 Act,
Yes.
you would have been
We would have been promoted.
promoted.
Yes.
That you have to show.
Yes,
clearly.
I have done the entire calculations, in fact, in my writ petition also, and thereafter also, in fact, by a subsequent order, the Honorable Court, considering the law laid down by the Honorable Apex Court as well as the mandate of the Act, had directed them to file an affidavit stating how many people under the disability with disabilities in terms of the Act has been accommodated, promoted, whether there is any backlog. how the vacancies have been. In fact, in terms of that, they have been they filed an affidavit stating that this many persons were appointed under the Disabilities Act. But if I take your lordship to the record, there's an OM there, as I have already submitted. There was an OM. Their plea was that the OM mandates that we can promote persons only beyond, only up to Group C post, not beyond that. That is their basic plea. And subsequently, as the Honorable Court had stayed the offending clause in that particular OM, they came up with a new OM, so amended OM, providing, in terms of the Honorable Apex Court's decision, providing reservation in promotion to disabled persons beyond Group C post. That is also in Group B and Group D post. And that came only in the year 2023.
23.
Yes. That cannot be a plea that just because the OM...
And they will say that it would not have a retrospective.
Yes, yes. But that cannot be, that
So
will
by
be...
that, by the
yes.
time, by the moment new OM has been by the time it is notified, you are already promoted on your own.
Yes. That,
normal
yes,
proceeding.
they cannot take their plea that OM cannot be given retrospective effect. And we are seeking retrospective effect to our promotion on the basis of the law laid down by the Honorable Apex Court, because we had a valid claim existing on the day when we filed the writ petition. And when the orders in the writ petition are deemed to take effect on the day when the writ petition is filed, because if there is a valid claim, legally valid claim existing on the day when the writ petition is preferred, then the date, then the judgment of the Honorable Court will take effect from the date when the writ petition is filed. Yes, that is our simple reasoning, on the basis of which we are staking the remaining claim, which claim remains in the writ petition. If I may take a lordship to the writ
Maybe
petition.
it's maybe very simple for you, but it's difficult for the court.
Lordship, yes, but
because it's not that
lordship,
simple
as I have been repeating, there is a law laid down. I'll be placing the Honorable
It's okay.
Court,
I've understood.
judgments
I've understood.
also. Judgments also on this
how
point.
how it has can be no,
Yes.
it's a
Yes.
basically if your prayer is allowed, it's basically amount to, I mean, considering a case for retrospective promotion
Retrospective promotion, yes.
only.
Only
Whether
that
that would be
remains.
permissible or not, that would
Yes, that yes.
it's not that simple. Your prayer may be very simple.
Yes.
But to consider and decide is not that simple.
I'll be placing Honorable Apex Court decisions also on this point,
Yes.
especially with regard to that benchmark these
Yes.
persons with.
Okay.
Lordship, it's an admitted fact that these persons have benchmark disabilities under the Act of 2016. So
there's no dispute.
I will not, yes, there is no dispute with regard to that fact.
Yes.
So I'll not be wasting time taking your Lordship to those documents. If I may take your Lordship directly to the OM dated 7/1/2019. If your Lordship takes up the second writ petition, that is WPC number 3299 of 2020. Or if your Lordship is taking up the first writ petition, it is there also.
3299.
3299. Page number 33. Sorry, 34. 34. Page number 34.
Yes.
OM dated 7th of January 2019.
Yes.
I'll just take your Lordship directly to the offending clause. Quantum of reservation, clause 2, 2.1. In case of direct recruitment, 4% of total number of vacancies to be filled up by direct recruitment in the cadre strength in each group of posts, that is grade 1, grade 2, grade 3, and grade 4, shall be reserved for persons with benchmark disabilities. Benefit of reservation in promotion for persons with benchmark disabilities will be limited to the grade 3 and grade 4 posts only, where 4% of posts shall be reserved for persons with benchmark disabilities, of which 1% each shall be reserved for persons suffering from blindness and low. These are the benchmark disabilities that is provided in the Act. And now, if I may take your Lordship to the interim order that was passed by this Honorable Court, It was first passed in the first writ petition, that is WPC.
What
double.
happened to that?
Lordship, this clause was stayed in both the writ
No,
petitions.
ultimately it's still pending.
No. That is what I was submitting, that this OM has been modified and a subsequent OM has been brought into effect by the authorities.
So no, that writ petition is closed.
No, both the writ petitions are pending. These are the two writ petitions.
No. This is in this has been filed in this writ petition or what?
Yes, in this writ petition itself, this was stayed. We had
Okay.
challenged this here itself.
Okay.
Lordship, the interim order.
Would clarify that the application of the interim order would be that if the petitioner is entitled to any promise under the law visible under this civil, the same shall not be denied by referring to the so and so, which has been stated by the court.
Prior to that, if your Lordship just takes up the preceding
In view of
paragraphs.
the proposition law laid down Supreme Court.
Yes.
Provision the officers will be limiting the benefits of result permission for the transfer result to the services. Yes.
Provision in the office memorandum dated 7/1/2019 to the extent of benefit of reservation and promotion for persons with benchmark disabilities will be limited to grade 3 and 4 posts shall remain state until further orders. It was state in a motion states itself, it was state.
In the second writ petition.
In both the in fact, in the first writ petition, the first interim order was passed on 1st of September 2020. Then in the second writ petition, which your Lordship is presently taking up, there it was followed. This order was followed there. Interim order was followed there also.
In second writ petition.
Yes.
21 September 2020.
Yes, but the first interim order staying of that offending clause was ordered on 1/9/2020 itself in the other writ petition 3317.
See, one technical difficulty may be, what is your prayer here?
In the writ petition?
Yes. Because initially you have challenged that notification.
Yes, we have challenged the
Modified
notification.
as to provide for reservation
Yes.
in under so and so. Consider the case of promotion post of
This prayer has been considered. This prayer has been, they have done it.
So this has been modified.
Yes, they have modified.
First
So
prayer
this,
is
no longer relevant now.
Now,
First prayer.
second prayer.
Second prayer remains.
Promotion in post of assistant engineer against post of would it not be required to file some amended petition?
Lordship,
in view of the subsequent development, you have to pray for retrospective promotion because you have been promoted now on your own merit, not by your reservation. So you are seeking from the date of you are seeking your promotion.
Lordship, my submission would be
Yeah.
that on the day these prayer will probably suffice. Not probably, this prayer will suffice. Why I am submitting is that because at that point of time, as I had already submitted, we had a legally valid claim in terms of the law laid down by the Honorable Apex Court. We were entitled to be considered for promotion, which was not done. That is why the prayer was that we have to be considered for promotion in terms of the Disabilities Act of 2016. So even as on date, even though we have been promoted, that claim still remains.
Yes.
So this is this was state. The offending clause was stated by that interim order dated 1/9/2020 in the writ petition number 3317 of 2020, and thereafter it was followed in the other writ petition also 3299. Lordship had referred to that calculation that we need to show in what manner our claims need to be addressed. At the time when the writ petition was filed, I had provided detailed calculation. If your lordship is taking up WPC 3299 of 2020, yes, page. If your lordship peruses page 11, paragraph 10. May I just read out paragraph 10? The petitioner makes a state that department has also initiated the process for filling up 30% of the vacancies in the post of assistant engineer by way of promotion from junior engineers. By notification issued by memo number so-and-so dated 6/8/2020, the provisional interstate seniority list of junior engineer under Public Works Department, Roads and Building as per Rule 22(1), 2 and 3 of the Engineering Service Rules 1978 was published. In the said gradation list, the petitioner's name has been reflected at serial number 312. As already stated, 260 posts of assistant teacher has been advertised for being filled up by way of direct recruitment. Considering the fact that the maximum of 70% of the total vacancies of the post of assistant engineer can be filled up by way of direct recruitment, it can be assumed that the total number of vacancies in the cadre of assistant engineer is 371. If 30% of the vacancies are to be assigned to promotees as provided in the service rule, then number of vacancies that remains from the promotees is 111. The vacancies of reservation for disabled persons is 4% as per the Act of 2016, and 4% of 111 posts comes to 4 number of posts. A perusal of the gradation list shows that there are 3 disabled persons placed above him at serial number 60, serial number 89, and serial number 186. Considering the fact that there should be 4 vacancies reserved for promotion of disabled persons, the petitioner has every chance of being considered for promotion against the quota for disabled persons. Further, considering the fact that there are only about 111 posts and the petitioner is placed at 312 of the gradation list, the petitioner apprehends that he may not be recommended for promotion as per seniority. However, he has every chance of being considered and recommended for promotion in the disabled quota. Also, as the service rules provide that the number of officers who would be considered for promotion is 4 times the number of vacancies, the petitioner comes within the zone of consideration for promotion. However, due to the presence of the OM dated 7/1/2019, the petitioner stands to be deprived of a chance of promotion under the disabled quota, even though the Disabilities Act provides for the same benefit. So in this manner, Lordship, I had provided the detail how I come within the to be considered for promotion under the disabled quota because I come within the zone of consideration there, and this is the number of posts which they have, and how I can
point of time.
Yes, at that point of time when the repetition, and subsequently what they have done, we have brought this everything into record. We have filed affidavits, and whether I can continue it to, if you please, that I'll be placing. Lordship, in the first half, I had submitted that the government advocate, they were directed to furnish the position of the number of persons that had been promoted against the disability quota. By order dated 10/2/23, that was directed, and as per that, they had filed an affidavit. If I may take your Lordship to that affidavit, which was filed
By which order?
by order dated 10/2/2023. The respondent number 1 was directed to file an affidavit indicating the directions as 10/2/2023.
Yes, where it is?
And they filed an affidavit. The pages, it starts at page 69. Nowadays, it's serial number of the 69. Yes.
I think it is 77.
Uh,
An
no,
affidavit filed by respondent 1 in compliance with this.
in the copy which has been served on us, the page
Oh,
numbers.
what is this? Why is there always difference of 69? Initially it's 69, now it's 77. Here. They are relying on 69.
In our copy, it starts at 69.
This is what?
Huh? 69. It starts at 61 and stops at 71, yes. Ends at 71, the affidavit.
I've got it.
Running page, yes, that is what
Running
I'm
page
referring
is
to.
77. Here 77. Anyway.
Whether that side of econ affidavit হয় না?
Same. In compliance of order dated 10/2/2023.
Yes, 10/2/23. Yes.
Vipul Chandra Barua.
Yes.
Burman.
Yes.
Yes.
If your lordship peruses paragraph 3, wherein they have provided the information as was directed to be furnished by the Honorable Court, they say that in compliance with the next page, aforesaid order passed by the Honorable Court, this affidavit is being filed with the following information. A total of 8 numbers of junior engineers belonging to the PWD category have been promoted to the cadre of assistant engineer, out of which 2 numbers of vacancy have been filled up, promoting in the PWD quota, and the rest as per seniority cum merit. There is no backlog vacancy in the PWD category. However, after the office memorandum of personnel department number so and so dated 21st May 2022 came to force, PWRD is promoting junior engineers to the cadre of assistant engineers while considering the 4% reservation for PWD category from the zone of consideration as per OM. Number 3 does not arise. How the department proposes. Lordship, the affidavit itself, they have everything is contradictory, because why I say, they say that 8 persons of the 8 disabled persons have been promoted and out of which 2 numbers of vacancy have been filled up by promoting in the PWD quota and rest as per seniority cum merit. They themselves say 6 numbers of persons have been promoted against seniority cum merit. Only 2 of them has been promoted against the PWD quota. Now, if they start, they have not started from the year 2019. It is evident because in the year 2019, the office memorandum which barred promotions in the grade 1 and grade 2 post was still in force. And it was stayed by the Honorable Court only in the year 2020, 1st of September 2020. And after that, the first batch of promotions which was affected was done in, I'll show from the records, I'll place those in 2021, 11/1/2021. And therein, they have not effected promotion against the PWD quota. And what the Act mandates is that in the Section 32 of the Disability Act mandate is that if the vacancies against the PWD quota are not filled up for want of persons suitable persons with benchmark disabilities, then the quota is to be carried forward. The vacancies are to be carried forward. It cannot be filled even by persons of other, if supposing one, what the Act mandate is 4% is for persons with benchmark disabilities. And further, the subsections provide that 1 person has to be provided for locomotor disability, 1 person for hearing, etc. That provides. If even that 1 person cannot be filled up for want of suitable candidates, then that has to be carried forward, at least for the 2 succeeding years. And only after suitable persons are not found, then it can be interchangeably filled up, persons with other benchmark disabilities. That is what the Act mandates. Here they have contradicted themselves. They themselves said that they have filled up just 2, they have promoted just 2 persons against the quota. So obviously the other vacancies should have been carried forward. they could not have filled up the other vacancies. Now they say there is no backlog in the vacancy. How can there be no backlog? Because the Act mandates that it needs to be carried forward. Now, I have
What does
filed
it mean? A total number of, a total
eight persons.
numbers of juniors belonging to PWD category
Yes,
have been promoted.
yes.
Total.
Total number of 8 persons. It cannot be, as I have shown from the calculations. In the first year itself, there were 111 posts that there has to be, as per our calculation, there has to be 111 posts for promotees. And out of that, if we say 4% is to be reserved for
No, it's existing. Why or how you calculating the existing vacancies or all entire vacancies?
not entire vacancies, vacancies against the cadre strength. Existing vacancies, yes, existing vacancies against the cadre strength. Now, if the
It's only 111.
for promotees, I'm calculating the 30% for promotion. Now, if we calculate total vacancies also, it comes to 370. Direct recruitment versus and vis-a-vis the promotees.
370.
Even if we, yes, 370. That is what I have calculated. If the total vacancies is also of the cadre strength is taken into account, 4% of that, it comes to around 14 probably. Now, out of that, 70% has to be as in terms of the in terms of the service rules, 70% for the direct recruitees and 30% for the promotees. Now, for 30% from the promotees, around 4 posts, minimum of 4 posts has to come to the promotees for persons for promoting persons with benchmark disabilities. Now, even if 4% is to be 4 numbers of posts has to be taken, starting from the year 2019, the Act came into force in the year 2016, and after that, we are not taking into account 16, 17, 18. We are not taking. We are taking into account from the year 2019, because probably only that on that year we will come under the zone of consideration. Petitioners in both the cases. So, starting from in the year 2019, the OM with the offending clause was still in force, and in the year 2020, that was struck down, not struck down, stayed by the Honorable Court, and with a direction that this will not be a bar for considering the promotion of these petitioners, promotion of persons with benchmark disabilities.
When you were promoted?
One of the petitioners were promoted in the year 22 and the other in the year 23. If your Lordship takes up the reply which we have filed against this affidavit, I have given a complete detail regarding the batches of promotions that were effected pursuant to the interim order passed by the Honorable Court and pursuant to the filing of this, and in what manner we come under the we have been deprived. The affidavit which we have filed, our running page is 72, but probably that will be not be. The filing date was 30/11/2023.
Yes, got it.
In the second, this case we have filed. I will start from paragraph, continuation of paragraph 4. If I may read out, Lordship, it will be more clear from that. Paragraph 4 starts at page 73. With regard to statement made in paragraph 3 of the affidavit in opposition, deponent begs to state, as per the provision contained in section 34 of the Right of Persons with Disabilities Act 2016, every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each group of posts and be filled up with persons with benchmark disabilities, of which 1% each shall be reserved for persons with benchmark disabilities under clauses A, B, and C, and 1% for persons with benchmark disabilities under clauses D and E. Though the government had filled up 4% of the vacancies in the post of assistant engineer meant for direct recruits by person with benchmark disabilities within the meaning of the Disability Act of 2016, but no promotion against the disabled quota has been given to the knowledge of the deponent. The office memorandum dated 7/1/2019 issued by the Personnel B Department provided that the benefit of reservation for promotion for persons with benchmark disabilities will be limited to grade 3 and grade 4 posts only. The present deponent, by way of the instant writ petition, has challenged the notification dated 7/1/2019, by which the petitioner and other persons like him have been deprived of promotion from the post of junior engineer to the post of assistant engineer PWD, as the cadre of assistant engineer is a grade 1 post. Though the Honorable Court, by the interim order dated 1/9/2020, had stayed the impugned notification dated 19/1/2019 to the extent of providing for benefit of reservation in promotion for the persons with benchmark disability to only grade 3 and grade 4 post, but record will reveal that no reservation has been provided for person with disability while granting promotion to the post of assistant engineer. It may be stated here that pursuant to the interim order passed by the Honorable Court, 3 batches of junior engineers PWD have been promoted to the post of assistant engineer civil. By notification issued by memo number so and so dated 11/1/2021, 83 junior engineer civil PWD have been promoted to the post of assistant engineer civil PWD. The final gradation list of junior engineer civil PWD was published by notification issued by memo number so and so dated 30/9/2020. Reading together of the gradation list dated 30/9/2020 and the list of promotees dated 11/1/2021 reflects that in order of seniority, the last person to have been promoted from the gradation list is placed at serial number 93. A perusal of the notification dated 11/1/2021 shows that there are 3 persons with disabilities who have been promoted on merit, their position in the final gradation list being at serial number 57, 64, and 86 respectively. Thus, it cannot be said that the 3 persons with disabilities who have been promoted have been done against the disabled quota. The petitioner in WPC number 3317/2020 has also been granted promotion, but not against the disabled quota. So 3 persons in the first instance, after filing of the instant writ petition and after issuance of the interim order, there was 1 batch of promotions effected, wherein the petitioner in the first writ petition, that is 3317, he has been promoted, but not against the disabled quota, but in terms of merit, because seniority and merit has been effected. 3 persons.
3317 is attempt 18, 19.
Item 18. Whom to first? 17 to Dulmala to first. Item 18, Lordship. Mohan to go over. Item 18.
Yes.
Notification and the promotees I have enclosed. May I just take your Lordship to that at page 71. This is the final gradation list of junior engineers. I'm sorry. First is the 11 January 21. This is the list of promotees of junior engineers. And if your Lordship sees the person at serial number 42, serial number 42 of that list, he is shown to be a PWD, but his promotion is on merit, because in terms of seniority cum merit, he has been promoted, serial number 42. As against his name, PWD is mentioned. Then thereafter, at serial number 53, there is another person with marked PWD. He also appears to have been promoted not against the PWD quota, but in terms of seniority cum merit. I'll show from the gradation list also, because their names are way up. And the third one at serial number 71, marked PWDs, Ishwar Chandra Goswami, 71. In that same page, he is also shown to be a PWD. But
It's
here,
shown, but the promotion has not been made.
no, not against the quota, not against the quota.
But it's in 2022,
That's it.
2 years back, even if you are allowed since 2020, better 2 years only.
Not 2020, we cannot claim, probably because after 20 also we have a valid claim. I'll place decisions on that point also with regard to benchmark disabilities. 20, even though we had a valid claim because of the Honorable Apex Court's decision and the legislative mandate, but what we are saying is that pursuant to the writ petition filed by us, 3 batches of promotions have been effected. And this is the first one, 11/1/2021. And the petitioner in the other writ petition has also been promoted in that batch itself.
In the first.
But not in terms of seniority cum merit. Not against the disabled quota. In terms of seniority cum merit. Now, even the petitioner in the instant writ petition, he was promoted in the year 2020, but not against the disabled quota. Now, he had a valid claim existing on the date when the writ petition was filed. At least when the first batch of promotions was effected on 11/1/2021, my case ought to have been considered, because I lose my seniority. I lose also notionally financial benefits also I lose. I stand to, notwithstanding financial benefits, my seniority I lose, because had I been promoted on that date, now because the persons who have been promoted in the year 2021, what we have come to know, they are going to gain another promotion very shortly. Now he stands to lose, these persons stands to lose in that manner also.
But the petitioner in this item 17.
Yes.
Was promotion was effected in the first
No.
DPC?
No, not in the first. Not in the first. He was promoted in the year 2022, 2022.
So in item 18.
Item
this
18.
Petitioner is first DPC after the filing of the petition.
Yes, first DPC after filing of the writ petition.
Yeah.
Yes, but what he is claiming that he in that case, after filing of the writ petition, yes, this is as per record, this is the first DPC. Yes.
On your own merit, why you should ask for reservation? Why
No.
you would ask for quota?
No, what
You have been promoted on your own merit.
yes, the petitioner,
As per the seniority of merit.
the petitioner in item number 18.
Yes.
What he is seeking that as on the date of the writ petition, I was eligible.
See, you may be eligible. That's the reason precisely I've indicated you. DPC was conducted
After filing
of the writ petition.
after filing of the writ petition, after filing of the writ petition. But when
Even if there was there any DPC or promotion order prior to that?
prior to that, yes, in Lordship, we have also to see when the Act came into force, and the Honorable Supreme Court judgment, because we were representing before the authorities that we have to in terms of the mandate of the Honorable Apex Court and as well as the mandate of the legislature,
More than
we have
also,
to be.
There should be a DPC.
Yes.
It's okay. They are supposed to have do it every year.
Yes.
It's not been done.
Yes.
Wrongly or rightly.
Yes.
Ultimately, they have done in 2021. And he has been promoted, item 18, Mr. Mahendra Gogoi.
Mahanta Gogoi.
Mahanta Gogoi has been promoted on its own merit. So why you should ask for a quota? That may be difficult. But so far as this petitioner is concerned, the first DPC, 2021, should have been considered.
Should have been considered.
In that case, it goes, Mahanta Gogoi case goes, we'll
yes.
close it. We can consider this present one, not
Not
the
sure.
other one.
He
Because
was
we cannot compel them to fill up.
no Lordship. There is no question of compelling here.
Yes.
Here is a case where Lordship, the direction, what they did not do was,
Suppose
there was
there
a mandate of the
there was a
legislature.
vacancy, right? The authorities has filled up the matter, filled up the post by following the rules, right? Where the 2016 Act, this should have been invoked.
But they did not do it. Did not do it.
They did not do it because there was no DPC as such.
No, after the Act came into force,
Yeah.
obviously there were promotions effected, but we do not have the record of that.
What to do?
We do not have the
If you
record
don't
of
have the
that.
record, what to do?
That record, Obviously,
And that's why we are counting from the date of when the office memorandum.
the office memorandum on the face of it.
2019,
Yes.
you have challenged that court has intervened.
Yes.
They should not be, I mean, it should be considered. Then next is 2021.
21.
Where the petition Mahanta, Mr. Mahanta has been considered
He
on his
has
own
been-
merit,
Yes.
not as per the quota.
Lordship, may I just verify 11/1/2021 on that? Eleven 2021, this person was not considered.
Where is the promotion order of 2021?
The batch of promotions that was effected at 70.
11.
Our serial number is 79. Please.
Yes. Where is the Mahanta, Gogoi?
That is what I'm trying to lodge. His promotion was
No,
effected.
you said he was promoted.
Lordship, I'm very sorry. I said he was promoted on 11/1/2021,
Yes.
but in fact, this person, Mahanta Gogoi, was promoted on 29 June 2022.
Yes.
At serial number annexure 2 of that affidavit, serial page is 92 as far as I don't, probably there's a mistake there.
Yes.
Notification dated 29 June 2022. 29 June 2022.
Where it is?
Annexure 2 of that affidavit.
Yes.
Serial, 29 June 2022.
Serial number?
Serial number 32. 32. Mahanta Gogoi, against his name, PWD is mentioned, but on as per seniority cum merit, he has been. So, not on, by mistake, I said 11 January 2021, but in fact, on 29 June 2022, he was promoted.
Then what about this present petition?
Yes. Present petitioner.
Then next TPC was, next promotion was?
Next promotion, December 20, this was 29, probably December 2022. Due to yes. Last document.
Annex 3.
Yes, Lordship.
Same day, almost the same year.
39, Lordship, his name is at serial number 39. December 2022, serial number 39. This petitioner.
30?
39. 39.
Dhul Malla Bujat Barua.
Yes.
Unreserved.
Unreserved. One.
So all these promotions were no reservation as per the act.
No,
only on its own.
On its own. On
As
its
per the
own.
rules only. No
Yes.
reservation, nothing.
No reservation. In the affidavit, they claim that 8 persons have been promoted. 8 persons with disabilities. With disabilities, that is what they say. And they themselves say that only 2 persons have been promoted against the disabled quota. Just there cannot be just 2 vacancies against the cadre, considering the number of vacancies and the cadre strength. There cannot be just two numbers of vacancies. Even starting from the year 2019 onwards. And after
Why they are mentioning PWD?
PWD, they have not mentioned PWD here against the name of the petitioner, but against
No,
the
it's 29 June 2022. Mahanta Gogoi.
yes, they have mentioned him as PWD, but if you peruse the gradation list, it will be seen clearly that he has been promoted in terms of seniority cum merit, not against the quota.
Then in that case, you show us with these 2 petitioners who are eligible if had reservation, 4% reservation was invoked.
Yes.
First 2021.
Yes.
You show us address 21, not before that.
Yes, 21.
First permission.
Yes.
After the Supreme Court and then the intervention of this order of this court.
Yes.
You could be at least at most
Yes.
directed to consider your case. The
Logic.
first DPC. We cannot say that you should have that kind of. I mean, there was even if there was a vacancy
No, yes.
before that.
Understand. Yes.
Just because it's in the teeth of the thing, the judgment of the Supreme Court, all the law, you just cannot. I mean, turn the clock
Yes.
back.
Only when there is a DPC considering
It will have
promotion
a- I mean-
against those vacancies, only then we can claim. Yes. So it's take a claim.
No,
Yes.
that also it will be difficult for us to direct them to consider those days before 2021.
Yes. At least yes. That
At
is
least
why
from
yes.
2021, we can look. I mean, we may think of directing them to consider.
Yes.
Provided if you can show us
Yes, Lordship.
that had the reservation been invoked in terms of the act, you would have been eligible and would have been considered.
Lordship.
That you show.
Yes.
That's all. Not
Yes.
before
If
that,
you-
huh?
Yes. Then
Because in
Lordship-
first DPC, since you were in the down below in the
Yes.
citizenship list, because it's a rule says seniority come merit.
Yes.
So your case could not be, you were not in the zone of the consideration, or maybe even if you are considered as per the rules, only on the basis of seniority come merit, there was no vacancy and you could not be considered. You saw us that during the 2021, there was a vacancy, had there been a quota, then both these could have been considered for promotion. It could have been promoted. You saw us to that effect only.
Yes, Lordship, I had already read out that paragraph, the
Paragraph
data
10.
which, yes, of my writ petition.
Paragraph 10.
Yes, I've made a calculation that at least 100 and, as per our calculation, at least 111 vacancies for promotees are there. For filling, for promotees are there.
Out of
And
111,
111, 4% has to be reserved for, in terms of the act, 4% for persons with benchmark disabilities. Now I have to show from the gradation list where their names are placed and how their names have not been considered. The gradation list of junior engineers, in that affidavit we have entered dated 30th September 2020.
page,
Page 83.
the addition, reply
Yes,
affidavit.
yes.
You tell your page 80,
83,
starts from
running
page
page.
83. Yes.
Lordship, in my writ petition, I have made a
Please to fix the interest in seniority, yes,
83.
yes.
Just show the name of the persons with disabilities here. First of all, I'll just point out the persons with disabilities. The next page at 84, serial number 57. This is one person who, as per our knowledge, he is a person with disabilities. 57. But nothing has been written against his name that he is a person with disability.
Yes.
Pradip Borua. 57. Next, 64. There is another person with disabilities. 64. Then next, 86. This is another person with disabilities. But and he
57,
is
64.
57, 64, and 86. These are the three persons with disabilities and the names of the present petitioners. Sure. The name of the petitioner at serial WPC 3317 Mohanta Gogoi is at serial number 179, page 87. 179. And the name of the Dul Malla Puja Borough is at serial number. at serial number 305. 305 at 89, page 89.
Yes.
Page 89. Now, if your lordship kindly turns to the preceding page, that is the list of promotees. There were 83 numbers of persons who were promoted from these gradation lists. 83 numbers. As per our calculation, there must be 111 vacancies. As per our calculation, but considering the fact that they have filled up 83 numbers of 83, as per record, I cannot exactly say how many number of vacancies are there, but considering the fact that 83 numbers of posts are filled up by promotion from the junior engineers, probably we are near about correct. 83 numbers of posts have been filled up, and I have shown from the gradation list that persons at serial number 57, 64, and 82. These three persons are persons with disabilities. These three. And 83 numbers of posts have been numbers of persons have been filled up. Now this number persons at 57, officers at 57, 63, their names are also reflected amongst the list of promotees. At serial number 42, Pradip Borua, whose name is reflected in the gradation list at 57, his name is reflected at 42 of the promotees list.
Yes.
42. That he is on merit, seniority cum merit. Then 64, Bhavesh Roy, his name is reflected at serial number 50. He is also on seniority cum merit, clearly. And the other persons with disabilities at serial number 86 in the gradation list, his name is reflected at 71. So clearly he is also on merit. He could not have been promoted against the disabilities quota. So the disabilities quota is clearly not filled up. So the next persons in line in the disabilities quota, I said number of vacancies, 4 times the number of vacancies that has to be taken. So if 4 times the number of vacancies is taken, as I have shown, my name is, one of the petitioner's name is at 179 and the other is at 305. If we take 4 times zone of consideration, clearly these 2 persons come in.
$179.
Yes, 179 and 305.
How?
4 times the number of vacancies.
4 times is only consideration.
Zone of consideration.
Yes.
Zone of consideration. That is what we are saying. Zone of, these are the we come in the zone of consideration. So there are, the disabilities quota is open here because the disabled persons who were there.
How much it should be out of 83? According to you.
Number of vacancies, our calculation, as per our calculation, the number of vacancies is 111. They have not given what is the number of exact number of vacancies. That information has not been provided by the authorities in any form in any form here. So considering the fact that 83 numbers of persons have been promoted from that gradation list of junior engineers, so we can say that near about maybe we are correct.
Before you, both of you, there are 3 persons.
There are 3 persons, yes, but they, clearly they are on merit, not in the disabled quota.
Obviously, even if it's on.
No, merely they are on merit. If they are,
Suppose, assuming that they have been promoted on their own by invoking the assuming that they have been there. Their zone of consideration, their PWD, right?
Yes,
so
they are
first
PWD.
preference will be given to them, the seniority come merit, isn't it?
Lordship, why they cannot be considered to be promoted against the quota once, even if a person with that is what the law has been laid down by the Honorable Apex Court in terms of say person with in a SC or ST caste. supposing he is number one in the merit list, he cannot be said to be if he has been promoted on merit, or if he has acquired that he has been successful in the merit list number, he cannot be said to be have been appointed against the quota. He is on merit. Same principle goes for here. They have been promoted as in terms of their seniority. These three persons, yes, they are persons with benchmark disabilities, but they have not been promoted against the disabled quota.
Because there's no question of quota, because there no quota has been involved.
No, quota has to be filled up.
It has not been done. Therefore, there is no question of quota.
No, quota remains open because the persons who are with benchmark disabilities, they have come on merit. They cannot be said to have filled up the quota. They cannot be said to have filled up the quota. The quota remains open. They, in terms of their seniorities, they have come in the promotees list, not in terms of the quota. So the quota remains open. So the next in line, the persons, other persons who are in the zone of consideration and with benchmark disabilities, they have to be considered for being promoted against the quota.
I've understood.
Yes.
According to, had there been a quota, at the Act of 2016 is invoked by providing a 4% quota.
Legislative mandate.
Since 3 persons who have been promoted in 2021, they were promoted on their own merit. Therefore, they could not, even if there were three PW persons,
yes,
they could not have consumed the quota.
Yes.
They could not have been promoted on the basis of the quota.
Yes.
Even if they are PW.
Yes, they cannot be considered to have filled up the quota.
Therefore,
Lordship.
the rule permits 1:4 ratio
Lordship.
for consideration.
Yes.
You falls under that thing, and if had it been done, you could have been promoted in 2001.
Yes, that is our case.
You just give that what you have submitted. I mean, out of the arithmetic, statistics.
Yes.
That
calculations.
Total and all those calculations, you give me that.
Lordship,
referring to all this will be different.
Yes, I'll place one decision on with
You just give the decision. What is the decision? Yes.
Lordship, so far as
How many decisions? Only relevant to
I'll place one decision.
Only one.
One decision.
Yes.
And one more on Article 141 that when there is a law with regard to, or probably I don't know whether maybe I'll not be required to place it also. First of all, yes, this decision. This is with regard to that reservation in promotion for persons with benchmark disability. Now, after that, this Rajiv Gupta's case in 2016, pursuant to which and in accordance with which the offensive clause in the office memorandum was made, and by which the Honorable Apex Court laid down the law that irrespective of the mode of recruitment, whether by promotion or direct recruitment, the reservation in promotion. This was a case from the state of Kerala where the respondent, there the Honorable High Court had directed her promotion in terms of the Disability Act, and also retrospectivity was given when the day she was eligible for considering eligible for promotion on that day. Now the Supreme Court affirmed that judgment of the Kerala High Court, and this was what I was going to place. Then at the relevant paragraphs. And there was another point here which was raised here, was that on the day, at the time of the initial entry into service of that particular respondent or that particular person, she was not a person with disabilities. Same goes for one of the petitioners here also. After that, she acquired the disability. Now, whether if the person was not a person, initial appointment was not by way of not by way of a disabled person, whether one can be considered for promotion against the disability quota. The Supreme Court held that the mode of entry into service is not relevant. If what is relevant is that on the date when the consideration for promotion is going to take place, if the person is one of with benchmark disabilities, then it is that the person then the promotion can be effective. And the relevant paragraph, just paragraph 20 of the judgment. Paragraph 20, page 12 of the judgment. Lordship, I'll just read that paragraph 20. The question there was, issue was whether in absence of a provision in the rules for reservation in promotion for PWD, whether promotion can be denied to a PWD. The aforesaid issue was raised by learned amicus curiae in the context of the plea of the appellant state that the state does not provide for any reservation in promotion for PWD. Thus, a person with disability would be considered for promotion along with other persons working in the feeder cadre. We have no doubt that the mandate of Section 32 of the 1995 Act enjoins the government to identify posts that can be filled up with persons with disability. Thus, even posts in promotional cadre have to be identified for PWD, and such posts have to be reserved for PWD. The identification of such posts is no doubt a prerequisite for reservation in promotion for PWD. There cannot be methodology used to defeat the reservation in promotion. Once that post is identified, the logical conclusion would be that it would be reserved for PWD who have been promoted. The absence of rules to provide for reservation in promotion would not defeat the rights of PWD to a reservation in promotion as it flows from the legislation, and in our view, this is the basis of the mandate of this court in Rajiv Kumar Gupta's and Siddharaju's cases. The only caveat to the aforesaid would be if the government is of the view that a post in the promotional cadre cannot be reserved for PWD category due to functional or other reasons, and that should not be used to defeat the reservation in promotion. We are conscious of the fact that such a scenario will result in frustration and stagnation, as others may get promoted even over the persons with disabilities as submitted by the learned amicus curiae more often than not. The disability comes in way of meeting the requirement for promotion. In such a situation, we would require the government to explore methods to address the issue of stagnation of a PWD. Next, we can see why I'm referring to this paragraph is that because it refers to the issue of identification of post. Now, what is also essential is that once the post is identified, now the fact here.
Gupta you have? Rajiv Gupta you have?
Yes, Rajiv Gupta, we have already, it's there in the record. Rajiv Gupta, decision 2016-13 SSC. 13 SSC.
Where is this?
We are placed on record. 2016-13 SSC 153, Rajiv Gupta. This is this. This is not from the SEC online. This is from Supreme today.
This is paragraph.
Paragraph 10-11. It's there.
Then next one.
Siddharaju, Lordship, after Rajiv Kumar Gupta's case came, the Union of India did file a review and other miscases that Rajiv Kumar Gupta goes against the decision of Indra Sawhney's case, which mandated that not more than 50% of reservation. This filed a clarification, in fact, a review petition was filed that was dismissed, and the Honorable Apex Court affirmed the decision in Rajiv Kumar Gupta's case and directed that the directions in Rajiv Kumar Gupta should be strictly implemented. And in between that, in fact, in Siddharaju's case, Siddharaju's decision I had placed, it is the citation is 2023 scale 99. I had this can be see. Like at the time of motion, Lordship, I placed this decision. This is my, but I'll place a fair copy. This is marked, Lordship, highlights. And those two decisions have been referred to in the interim order also, that is why. Lordship, that identification issue which I am referring to here, as has been referred in the Honorable Apex Court's decision, is that the post has to be identified that it is suitable for persons with disabilities. And here, the post has already been identified. That is evident from the fact that in case of direct recruitment, all the advertisement for direct recruitment, we had placed those advertisement in our writ petitions. The 4% reservation for persons with benchmark disabilities has been clearly stated there, but only for promotion. Now, one more paragraph from that Lesamma's decision, which I placed, State of Kerala and others versus Lesamma Joseph. One more paragraph at page serial number 15, paragraph 26. Serial number 26. If we may, the issue was whether the respondent can be promoted by giving benefit of reservation as she is a PWD, despite the fact that she was not appointed in the PWD quota. If we may say so, this was the most crucial issue which persuaded us to grant leave in the SLP. The direction in the impugn order was for the respondent to be considered for the promotion based on disability at the time when the claim originally arose, but subject to her seniority with reference to other PWD candidates entitled to such reservation. She was also held entitled to the notional benefits of her promotion from the date she was so found entitled. In the factual context, it has been pointed out by learned amicus curiae that the respondent had claimed the promotion to the post of UDC with effect from 1st of July 2002 and further to the post of cashier with effect from 28 May 2012. The endeavor of the amicus curiae was to obtain necessary information from the appellant state and to seek their response. In this behalf, it has been pointed out that the Ministry of Social Justice and Empowerment in the Department of Empowerment of Persons with Disabilities, Divyang, Government of India, has undertaken a very comprehensive exercise of identifying posts which can be reserved for PWD, and the list of such posts are available on the website. From that, it appears that the post of UDC cashier would be amenable to reservation for PWD, and thus there can be little doubt that the respondent has been capable of discharging functions of the promotional post, and thus could not be denied the benefit of reservation, even if the rules do not provide for any reservation in promotion, as repeatedly observed by us that Section 32 of the 1995 Act is to facilitate but not to impede the legislative mandate. Now, the 2016 Act has taken over the 1995 Act. And what Honorable Apex Court says is that on the day when her claim arose, that at the time when the claim originally arose, that is what the Honorable Kerala High Court had decided. The impugn order was against the order of the Kerala High Court, and the Supreme Court affirmed that yes, when the day her claim initially arose, she is entitled to promotion from that date, and also the notional benefits, etc. That the order of the Kerala High Court was not interfered with by the Honorable Apex Court. So in terms of that, even the present petitioners, their claim arose at least from the date when the first batch of promotions were effected pursuant to the filing of the writ petition, so they are also entitled. And that is my decision. So I'll give a breakup of the.
So this prayer number 1 it's become redundant.
Redundant, yes.
Because they have changed they issued a fresh notification.
Yes, yes.
Saying that it will apply to.
Yes.
Beyond
grade 3, yes.
Okay. Same year, appointment is same year.
Appointment is not same.
Disposed of in the common order.
It can be. Appointment is not the same year, but it can be disposed of by common order.
Yes. What is to be done? We have heard it. Why tomorrow? We are completing it today. Any other method? Any other method? Huh? Ready? Anybody ready?
সেইটো বিচাৰা মই তেওঁক নহ'লে অলৰেডি মইতো বিচাৰা মইতো ক'ব নোৱাৰোঁ ন তুমি কোৱা ফেচ কৰা দিয়ে চাবমিশ্যনছ মই বুলি কোৱা দিয়ে মই কৈ দিছোঁ
Call him. We'll timely. Just record. We'll just say, we'll hear him.
Lordship, yes. Even Lordship, I do not want that in his absence any order should be passed. Let him make his submissions. If you
But you give that statistics
Lordship,
by today.
by today. Yes, I can. I'll provide.
Relevant which you have submitted.
Synopsis.
Not synopsis, that is statistics.
Only those number, yes. The number of persons promoted, yes, vacancies.
Promoted, when, how,
Yes.
how you claim that statistics only.
Before, yes.
For my
Lordship.
understanding.
Lordship, I'll hand it over to the court master a bit later. Lordship.
After hearing him then.
Lordship. After the hearing is
You'll be
concluded.
here, he may say something.
I'll be here. Yes.
Yes. 23.
This happening on very narrow area. Right? It's on factual inconsistencies. It will not take much time. What is happening, Lordship? I have challenged the calculation made by the learned member regarding the income of the deceased person.
What do you say?
I've just referred to 3 documents here, exhibits.
What do you say?
My lord, what they have disputed, my lord, the exhibit 7, my lord. I think this is okay, my lord. There is no discrepancy in it. I have flagged my gift, my lord.
What would be the difference?
Difference, Lordship, is about 5,000 of income. There are other areas also. Basically, it is to the what should have been the monthly income. That's may refer to these 3 documents 10456.
Yes.
In one is it's a salary slip for the month of August, September, and October. He died in November.
What is the difference? If suppose if your submission is accepted,
Yes, Lordship.
what difference would be there?
I understand.
What is the award? How much?
58 lakhs, 19,206.
58 lakhs, 19,206.
Yes. Then
58 lakhs. Lordship. The learned member has considered the annual income of the deceased as 5,80,428.
annual
Income
annual income
of the deceased as 5,80,428.
Yes.
This, Lordship, Harry, of the opinion that is not correct.
Which one?
This 5,80,000, there is no
Yes.
basis. I don't know on what basis
No,
he
which
has calculated.
paragraph he is? Where is that finding?
My lord,
It is in para number 2021.
The claimant SPW1 in her evidence stated at the time of their husband working in they also disclosed the decision they required one in engineering. 48,000.
The 3 documents which have been relied upon by the claimant is in page LCR 104, 105, and 106. Salary slips for the months of August, September, October 2016.
Why you are disputing it?
No, but these are different. They are not the same. They are not the same. In the month of Lordship,
No, it was found to be 48,577.
that is not correct.
this is as per exhibit 7.
No,
my lord.
let me.
Gross pay 48 According to how much it should be.
Lordship, there are three, all the three different figures for 3 different months.
Forget about it.
No. So
But
one
according
is,
to how much is the gross?
in fact, Lordship,
You
what
take
is,
into account of these three.
yes, Lordship,
You take into account of these three documents.
these 3 documents,
Even if you assuming that there's a discrepancy in the documents,
yes, Lordship.
you take the average of this gross. What is the gross?
Gross,
It's a farmer.
Lordship, as
It's
per,
not a
as,
business. He was not a businessman.
no, he was a salaried person.
He's a salaried person.
Salaried person. He was a salaried person.
So,
So
according
as,
to you, I just wanted to know what is
yes,
what will be the
Lordship,
gross.
I'll just come to,
Forget about that. Just tell us.
it should be, Lordship, in fact, 3 different figures, Lordship. I don't know, I'm in one figure it is 40,646, but it has been corrected back to 38,316.
Then
In another, it is 39,626. This figure, Lordship, the figure that London member seems to have taken is 48,577, but this contains a area component of 8951. So it comes to monthly figure comes to 39,626. Again, in the under year, it comes to, it's shown as a 74,000. There are wide variance, Lordship, 30,000, 40,000, 70,000. But here again, it consists of an area under some head of 33,479.
no,
So it probably is around 40,000 is the correct.
Para 20 it's clearly said gross pay of rupees 48,577.
He is relied on only 1 month's salary slip, Lordship. There are 3 salary slips here. In fact, how can the salary differ so widely in 3 months?
Monthly salary of the
The government employee.
after deducting 205 is proposed only and thus total annual. Yes, according to you, what is
On top of it, no income tax was deducted, Lordship. There is an income tax
income
paid.
tax is not required.
It's required, Lordship. Income tax has to be, the statutory deduction has to be there.
How much?
That will depend on the quantum, Lordship. We haven't quite decided on what is his monthly annual income, on what is the
That's why
relevant.
they say it doesn't fall beyond the slab.
That was 2,50,000 was the exempted limit at that point of time. Anything above 2,50,000 was the.
Will not going to.
No,
But
that-
according to how, what is the gross salary?
My lord, we have.
It cannot be changed in every month.
My lord, yeah,
The difference is huge.
yes, huge difference, my lord.
According to you,
According, that is why, my lord, this exhibit 7 was taken into account by the London Tribunal, my lord.
Exhibit 7 is what?
For this is for salary slip of September,
Last salary slip.
just before 1 month, my lord. Last salary slip was October. October it was 40,646, and September it was 48,577, my lord.
Huh?
48,577.
Ah.
The London Tribunal, this
Let us see the record. What is it? Page.
I have flag marked the salary slip, my lord. Red flag, my lord.
This one.
Yes, my lord. 3 salary slips were there, my lord.
Hmm?
There are 3 salary slips, my lord. Exhibit 6, 7, and 8. The London Tribunal take into account, my lord, Exhibit 7. My lord.
Exhibit 7.
Yes, my lord.
Why there is a difference? Huge difference.
Difference, my lord.
Why there is a huge difference?
My lord, that is also, my lord, I am not aware, my lord, about this difference, my lord.
You must be aware, sir. Then how do we decide? Huh?
The Railway Authority, my lord, evidence, my lord, in this case, my lord. The Railway Authority also submitted their calculation, my lord.
Exhibit 6. Document 7. Provisional salary for August 2016 notice. Look at this. Exhibit 6.
Yes, sir. 74,142.
Yes.
That includes a area under some head for 33,479.
Okay. Then
If it is deducted, then this will also come down to about 40,000.
Gross
40,
48.
48,570.
Then why 40,000?
40,646.
Gross means what? Once gross is gross.
This gross is the amount to be taken.
Ah,
But not including, I mean, it can be so varying. It has to be annual income. Either he has to produce a consolidated annual income statement.
Dismissed.
No, it can be dismissed also. There are other ones.
Writ
Lordship.
appeal,
No,
the
Lordship.
MSc appeal dismissed.
No, Lordship, it cannot be.
Why?
Lordship,
It
Lordship,
has
give me
been
just 2
grown.
minutes, sir.
Why? What?
Lordship, I have a good ground, Lordship.
What good ground?
Lordship, the starting point for calculation of the compensation is wrong.
How?
Lordship, 3 statements show almost monthly gross as 40,000 minus the areas.
Where is the statement?
This is 104, 105, 106.
Yes.
In one, it is 38,316.
Yes.
In one is 39,626.
It's not.
Yes.
It's your calculation. The printed one is 40,000.
Yes, 40,000. Even if it is taken as
Why
40,000.
you are, how you are calculating? It's a provided by the
Lordship,
office.
he has
SSL
taken it as
Pro.
40,000.
Who has given this?
Lordship,
Salary slip has given by whom?
by the department.
Department.
Yes.
How you can change that then?
I'm not changing it. Lordship.
Then
Lordship, just give it to me, sir.
look at it.
No, I have looked at it. That's why I can tell the gross and the areas. also.
You have
Lordship,
calculated
the average-
overhead. You have calculated. See, I can under 74.
Yes.
104.
Yes.
This is 74,001 and it includes some areas. All right.
Yes.
That we can understand. Then what about this second 105 exhibit 7?
That also contains area of 8,951.
Where it is?
It's just above the total, Lordship. 8951.
89?
Area under BC or some what is it?
Yes. Then
the next one it is 40,646, but finally by hand it was corrected to 38,316.
who has done this?
No, that must be departmental. So
Ah,
but even if we take it as Lordship 46,746, it comes to 40,000, not 48,000. 48. The member has taken it as 48,000.
yes.
It should be 40,000 in that case. 3 documents show it as 40,000 base figure. That is my point, Lordship. And on top of it, Lordship, it says the settlement position of law income tax has to be deducted, Lordship. This is a case which attracts income tax. Lordship, may have a look at this. It's a settlement position of all statutory taxes have to be deducted. That's the only deduction. Professional tax at 208 rupees per month or this and this one.
Where it is?
Let me just give it to me.
Huh?
It's there. Let me just. Yes. Lordship may see income tax returns in this case. This relates to the other judgment, but this says in this case accident had taken place on 7/5/19, para number 21.
Paragraph.
Paragraph number 21, Lordship.
Hmm.
I should have relied on some other judgment, but in this case, this also says income tax returns were filed on after the accident. The income tax returns therefore have rightly been not reliable because in this case, returns was filed after the accident to make some gain out of it. But returns is a genuine year considered. It has to be taken into consideration. Lordship, in that case,
How do you understand this?
no, this is a case, Lordship, is a different context. I made a mistake.
Then
Lordship,
it is a different context then.
No, Lordship, income tax has to be taken. In this case, income tax return was not considered because this was filed not before the date, but after
Paragraph
the date.
21, on what basis will rely on this? How you are referring
Lordship,
to it?
this may be taken up the day after tomorrow or maybe next Monday. I'll produce that judgment where income tax is a professional, statutory taxes have to be deducted.
Why you are placing this?
No, this one, Lordship, was in a different. It relates to income tax, but in a slightly different.
Goswami, don't confuse. The
No,
issue
no,
is very simple.
I never do. Lordship. This is just to show. I use it very frequently. to show the income tax return after the accident should not
Where
be
is the
considered.
judgment?
That
Which you are
is-
frequently using it. Where it is?
This is no, Lordship may allow me to explain this. This judgment I rely on to show the settled question of law. The returns filed after the date of a person or the accident cannot be relied upon. This is the judgment. And that even pronunciation and others they show income tax have to be deducted, statutory deduction. Lordship may give me just one day, I'll show it very clearly. Statutory taxes have to be taken into consideration. This settled position of law, Lordship. This was suddenly relied on because this also income tax returns ought to be considered. That has been considered, but this was found to be after the accident. That's why it was not considered. Otherwise, it's a standard procedure.
We'll take the base gross 40,000.
Yes.
40,000 something, not 48,000. All right.
Yes.
40,000
Yes, sir. Yes, sir.
to the extent of 40,000 base
Yes, sir. But
gross monthly.
yes, sir.
That's all. On the consent.
On some other day, Lordship, I'll explain statutory deductions have to be taken into consideration. That's a standard. I never make a misrepresentation.
I'm not saying misrepresentation. I'm saying why
No,
you are
this one was
why
not
you are
this-
placing a judgment
No,
which is not
no,
relevant
no,
also.
no,
How do it's a one sentence?
No,
How do we realize?
Lordship, what I meant to say even this way, the income tax returns are a part of assessment.
Nothing doing.
Only in this case, this was not taken into consideration because it was
It's a
beyond
motor accident claim. Your insurance company 48,000 will be huge difference. We'll take it on the base 40.
yes.
No income tax, nothing to that extent. Appeal disposed of. That's all.
Yes.
We'll agree to your submission.
Yes,
Base
yes,
has
yes,
to be 40,000. That's
Yeah,
all.
yes, yes.
40,000 something. Last one.
Yes, yes, yes.
Page 108, 106, Exhibit 8. We'll take the Exhibit 8 and modify it accordingly.
Yes. Obliged.
Dispose of. Only to the extent of, you just said, should I dictate here? Just is hard, Mr. R. Goswami. R. R for?
Raju.
Raju. R. Goswami.
The most
Leonard.
popular name in India.
Okay. Not Rahul.
The most popular name in India.
No, Rahul is more popular than
Right
Raju.
from Raj Kapoor's days, 1960s to.
But nowadays, latest
still
trend is Rahul. नाम तो सुना होगा.
नाम तो सुना है Lordship.
R. Goswami, learned counsel for the appellant. And Mr.
A. Zahid.
Learned counsel for all the respondents.
All the respondents.
All the respondents.
Yes, all the respondents.
How many respondents?
4 respondents. Yes.
All claimants.
All are claiming.
All are claimants.
Yes, yes.
Okay. Just take the.
Yes. Yes, sir. Yes, sir. That is it. Yes. Yes.
Yes. Yes. Yes.
Obliged.
Obliged.
I'm sorry, I was in the other court. I'm told that the petitioner has made their submissions. My colleagues have taken note. I pray little accommodation till tomorrow. I'll make my submissions tomorrow.
This year, sir. We thought of closing it today. No, simple, I'll tell you. You just give your this thing. We have seen your affidavit also.
My lord.
It's a mandate of the law. You should have the 4% reservation, PWD.
Yes.
Now, Supreme Court after Rajiv Gupta and all, you had your own policy, notification
My lord.
2019.
Yes.
By the way of the writ petition, they have challenged that notification.
True.
And the first day, as by way of interim order, that has been normally, not state as such, but there's a direction was given that it should not come in the way for consideration because it's a mandate of the law as well as the Supreme Court has clearly given. So it's you have to do that.
My lord.
Now it's all become redundant by now because you have a new notification.
We have
where you have provided that it should be beyond grade 3 and grade 4.
To all,
so it's
all-
applied now.
To all classes now.
Now what they are claiming is that since you have acted on the seat of the mandate of the law as well as the Supreme Court, they could have their promotion could have been given retrospective. By now they have been promoted.
By now they have been promoted.
Now what this code is of the permissive view that not from the date of existence or the vacancy and all things. After they filed the writ petition, you have effected first promotion in 2021, promoting 83 assistant junior engineers to the post of where you have not invoked all this, applied this reservation. So prima facie, we find that you should have considered because your policy, the rules, it's for promotion. You will have to take the 1:4. 1:4, right? Then, as per the seniority list of the junior engineer, they also falls. If it takes the in terms of the 2021 promotion notification.
To 21 office memorandum.
Office no 21 that promotion order.
Promotion order.
Right. We find that will allow to the extent of because the challenge to the first prayer is it has become redundant because you have changed your notification.
Malad.
Now second prayer for consideration, not exactly a retrospective, but we find that by now, of course, it has become redundant. But first promotion, had you applied that mandate of the law as well as Supreme Court, they could have been considered.
At that point of time.
At that point of time.
But,
so we're not beyond that. The first promotion after the filing of the writ petition was 2021. That will allow to that extent. That is the prime view.
Malad, the office memorandum which was under challenge in this petition,
Yes.
that restricts the consideration of reservation to a particular class, not only to grade 3 and 4, not to higher grades.
Yes.
That was under challenge and it was an interim order was passed to that extent. But subsequent to the Honorable Apex Court decision,
Yes.
and the government of Assam has also taken its own decision and the office memorandum has been issued.
Yes.
And it was on 21st of May 2022.
Yes.
But my respectful submission would be, Lord,
Yes.
the promotion itself is not a right of the person.
Okay.
It is the consideration for promotion that is the right. And my lord, my submission would be that the promotion has to be considered as per the rules. The rule has to be there, and only as per the rule they can be considered. So the office memorandum which came in 21st of May 2022, it takes care of the situation, and as per this office memorandum, now the promotion has been considered and they have been given.
No, not even then also. Now also they have not been because they falls under their own merit, right? There are in 2001 also
21.
there are three PWDs, right? 3 PWD were promoted, but then they on their own merit.
Merit, because at that point of
So
time,
they even if there are 10 or 15 PWDs, you cannot say that they were promoted. In fact, you have not applied that law only.
because the OM came in May 2022.
OM is what, sir? You cannot have you cannot have a recruitment rule. beyond the against the law.
We cannot, but ultimately,
So it's as good as not. It's not a. I mean, OM. It's not a law at all.
the recognition of the right of
It's 2016.
of that, well, it is there, but it was the implementation takes time. It is implemented by the office memorandum on 21st.
Practically, we understand, but we cannot have give leverage just because the implementation takes time.
But 21st of May 2022, as per this model, we have to go. Otherwise,
In fact, this promotion that has it doesn't show anything that you have applied the 2016 Act even after in their promotion also.
no,
They have promoted on their own merit because its rule says it's a seniority come merit, right? So they have been promoted on their own merit, not because of the quota. They are seeking on quota because what they are saying, had the law been implemented, they would have been promoted
long time.
much before
Long time.
2017-18. But this code is also viewed that will be too cannot stretch too much. After the filing of the writ petition, the first, at least, this court finds that at least their case could have been considered by invoking the law, applying the law in 2021. That much we are directing.
But
Writ petition allowed.
I have the minus